having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, keep your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Okay, good morning. And welcome to today's sitting of the Appeals Court. To begin with, my name is Ariane Vuno. I'm joined today by Justice Sabita Singh to my right and Justice John Englander to my left. I see a lot of veteran litigators here, so I'll just quickly remind you that you only have 15 minutes to present your argument. I can assure you that the panel has read everything you've provided to us, and we know the record very well, so you can use that time to get right to your main points. I also want to remind you that there is no rebuttal in the appeals court. Finally, we intend to take a short morning recess after the fourth case, and that's all you really need to know before you start. The first case on our list is Commonwealth versus Brian Corley. Counselor?
Good morning. May it please the court, Christopher DeMeo for Brian Corley. So this appeal is limited to Rule 36 issues. It was an OUI case. There are three sub-issues relating to three different periods of time, so I'll just go through them chronologically. The first period that's in dispute stems from an August 15th. In August 15th hearing, the party showed up to address a motion to dismiss that Mr. Corley had filed. It was a no-fix motion to dismiss, arguing that he didn't get the citation properly. The ADA was unprepared to go forward that day, and she asked for an extension to September 13th. There was no objection at that time.
Right. So if nothing had happened on August 30th, you would agree that that time would be excludable?
I do.
Okay. So tell me why then, when the Commonwealth came in on August 30 and asked for additional time, why that initial 2 weeks or so should not be excluded?
Well, it's a waiver analysis, and waiver is knowing relinquishment of a right. So, I think it's appropriate to look to what Attorney Tabner was thinking on August 15th. And on August 15th, he thought, well, our deal is you get a 1 month extension. And
Why do you say it's a waiver analysis?
Because all the cases that talk about Rule 36 say when you don't object, you've waived your right to a speedy trial.
You waived that period to be counted, calculable under Rule 36.
Why do you say it's not a knowing relinquishment, at least until, I mean, if the relinquishment till August 30th is knowing and voluntary, then that's the end for you, right?
The deal, I look at it almost like
Can you just answer that? I want to make sure that we're on the same page.
All right.
If those 15 days or so are excluded, then the Commonwealth's okay. They got it in within 365 days.
Yeah, I have to prevail on all three of the periods that I'm going to argue to win. Yeah. But to answer your first question, Justice Englander, it's a waiver because that's what the case law speaks of waiving your right to a speedy trial. And what was in Attorney Tabner's mind on August 15th was, all right, our deal is you get a 1 month extension. I mean, this comes up all the time in civil litigation. One side asks for an extension, and either as a professional courtesy or for some strategic reason, you might want to agree to one period of time and not another period of time. I have my opponents that say, I'll need an extra month to write the brief. Don't usually have a problem with that. If they want 4 months and somebody's in jail, I have a problem with it. So it alters the whole analysis, and I think it's appropriate in this case to look at.
But it did alter the analysis here if we were to say that from August 30 on, that time is chargeable against the Commonwealth, so to speak. In other words, we would be acknowledging the fact that the prior counsel here waived Rule 36 for a short period, for what was considered to be a month, and then actually found out later it was going to be longer, and he's given full credit for that. In fact, even given an extra 2 weeks, so to speak.
I mean, if he had said nothing and had just waited to September 13th, the ADA could have shown up and said, I'm not ready, I need another extension. That was certainly a risk he was taking back on August 15th. I mean, that's always the case. But I guess what I'm saying is it's not appropriate to look at That's kind of like...
You want to go retroactively. You want what was said on August 30th to be retroactive.
I want, because it's waiver, yes, to look at
In what case do you have that you can tell us that it's permissible to have a sort of a retroactive analysis on a Rule 36
I don't really have
waiver?
anything. I'm sort of arguing from the general principle that it's a waiver analysis, but I do
Okay.
have I do refer to the reporter's notes, and I want to cite that because the reporter's notes say, because the Commonwealth, this is in the brief too at page 10, because the Commonwealth has the primary obligation for setting a trial date, a thorough examination of the record is necessary to determine whether failure to object should be counted against the defendant. So I take that to mean generally it's the case when the defense doesn't object that it's going to be charged against the defendant, but it's not an ironclad rule, and sometimes you have to look at the particular reason why counsel might not have objected on the facts of this case.
Okay.
And when you look at the particular facts here, I'd submit.
You want to move on to the next
Sure.
period of time, so to speak?
Yes. That one I really don't have a whole lot to say. They finally showed up on October 10th for this hearing, which was going to be an evidentiary hearing. And it turned out Judge Guzman just ruled from the bench, no, this argument is a loser. You can't have a no-fix argument because he was arrested, and let's set a trial date. So my argument is, when you read, the panel's read the August 10th.
Well, let's say hypothetically we agree with you, that from reading the transcript, it seems apparent that the judge did not take the case under advisement. In fact, what she said was, if you have other cases or something else to bring to my attention, you can renew this motion or bring it forward again.
Correct.
Let's assume for a moment that the panel agrees. There's, of course, a contrary notation in the docket that indicates that the case was, that the motion to dismiss was denied at a later point in time. So when there's a conflict between a docket entry and another portion of the record that's before us, don't we need to have someone make a finding on that as to which one is the appropriate?
No, I mean, I asked, I guess, in the alternative for a remand for a factual finding, but I don't think.
Well, how strongly are you pushing that?
I think that this court is in a good position to just read what she said and determine that it has to, the phrase is actually under advisement. That's the Rule 36 phrase. I just don't see how you can get that here. And as the Commonwealth points out as well, the docket is kind of a mess. I mean, part of it, I guess, was because of COVID and issues like that.
The language of the rule is actually under advisement. That's helpful, because she doesn't say under advisement. She does say, if you got something, bring it back.
Correct.
I'll take another look.
Right. And then so we don't think it's under advisement. That's my argument in a nutshell. And then the last point is, so this prosecutor, so they set a trial date of January 28th, back on October 10th. They show up on January 28th. Meanwhile, Mr. Corley's attorney, Tabner, has filed a motion to suppress results of a blood draw and analysis, which he thought was warrantless at the time. The attorney shows up again. She says, what? I don't know if he may have given that to me. I don't know, but I don't know anything about this. We're going to have to come back later. Apparently, sometime shortly after, maybe that same day, it turns out there was a warrant.
Was a search warrant, right?
Yeah, there was a warrant. So our argument here, and I agree that SJC's Taylor case is not exactly on point because that case involved a motion to compel, but I take the Taylor case to say when you have mandatory discovery, and the warrant was mandatory discovery, and the Commonwealth doesn't make mandatory discovery, a defendant doesn't have to choose between getting his mandatory discovery and waiving his Rule 36 rights. And in this case, there was nothing. The Commonwealth argues, well, you didn't file a motion to compel like in Taylor, but he had the blood test results, but there was nothing he didn't know until he found out about the warrant. And incidentally, the warrant, if you read Judge Fabry's decision, it wasn't produced until like 2 months later. So I really don't know what's going on, but I think it's fair here.
But the Commonwealth was sanctioned. In other words, everything was suppressed.
The Commonwealth was sanctioned that the blood test was suppressed by Judge Fabry. But I mean, it should have never happened.
So of course, the Commonwealth's argument, as you mentioned, as you talk about in your reply brief, is that you benefited from that.
Yeah, but I mean, that's not the kind of he should have had it all along.
You're saying it's sort of a collateral benefit, right? Is that what you're saying?
It's a collateral benefit. And so, I mean, I think this is the most interesting of the 3 points because it kind of, It's what does Taylor mean? I think Taylor means more than just you have to, that when you file a motion to compel, it doesn't stop Rule 36. I think Taylor stands
There's no question that the warrant affidavit and the warrant had to be produced as part of mandatory discovery, right?
When I look at Rule 14, it talks about producing police reports and police, I mean, that had to come.
Makes sense to me.
So that's sort of my three discrete arguments. And I just say generally, if you look at the whole kind of gestalt of the thing, seems to me a pretty open and shut OUI case. It really shouldn't have taken over a year. And when you look at the ADA showing up unprepared repeatedly, the things not getting produced.
You see, the problem with that argument is your first argument. Because your first motion was a no-fix motion where you should have known, your predecessor should have known, that his client had been arrested at the scene. And the delay, the initial delay, that initial 15, 30 days that croaks you, right, if it's not excludable, was based on a motion that arguably shouldn't have been filed, right?
Yeah, there's fault to go around, I guess, but when I talk about the gestalt, I'm saying when you look at the whole docket and all the things that happened, that was a sort of ill-advised motion. I agree with that, but when you look at the repeated delays and why did it take 2 months to produce the warrant? By that point, we're into the COVID state, but so to the extent this court does kind of have some flexibility under that rule, the reporter note I just quoted, I would submit this is the case to exercise that.
How long was it between arraignment and trial? 2+ years?
Yeah, it went from February 2019
922
to August.
days, right? 922 days? My math is correct?
That sounds about right, yeah.
Well, we can't.
I don't blame the Commonwealth for the COVID stay. But we wouldn't, as Judge Fabry said, you wouldn't have gotten there in the first place. In Judge Fabry's order, page 66, 67 of the record appendix, he says the whole reason we're here is because kind of dilatory.
Let me just ask you, are you, I don't want to shortchange your argument, but I have one housekeeping matter. I didn't miss it, did I? You did not make any constitutional claims, any violations?
No.
Okay, just wanted to be sure.
And I'll rest on the briefs if there's no questions.
I'll see if the panel
Thank
has
you.
any questions. I see none. Thank you very much for your argument. Commonwealth?
Good morning, Your Honor, and may it please the Court. Aaron Staudinger, Assistant District Attorney for Middlesex County on behalf of the Commonwealth. Your Honor, it's important to note at the outset that Rule 36 is a case management tool that is designed to enable the parties to accurately predict the time that's counting against them and not against them, and in order to enable a defendant to obtain a trial within a year if he so chooses. I think that's why a lot of these rules are a lot more rigid and don't enable this kind of backwards-looking thinking into how the parties would have acted. With respect to the first excluded time, the August 15th time to the August 30th, it was an unobjected to continuance. The case law is clear that the burden is on the defendant to object if the request for a continuance is not to be excluded. Here, there was no objection. And the purpose for that kind of thinking, that kind of rule, is to avoid this exact thing where it's like, was it a professional courtesy? Was it a strategic decision? The rule is built in to say you have to object. If you don't, it's excluded. I think that rule is very clear. And even then, as you note, if we were to do this logic that the defendant encourages on appeal, the internal logic would be that the time until September 13th was excluded, which doesn't really comport with the rules. That's why the case was brought forward, in order to say, hey, we actually do need more time. And at that point, the defendant was able to lodge an objection. Now that this additional time was requested, that's the mechanism for rule.
What do you say to the defendant's footnote where he makes an argument? I'm going to paraphrase it, and I'm not going to get it quite right, but basically along the lines of, look, this is the same thing as if somebody said, Judge, the prosecution says, I'd like an extra month. Defendant says, no objection. Commonwealth says, actually, I'd like 2 months, but the first month is not excludable.
Yeah, and I think that's exactly...
Or is excludable, yeah.
I think that's exactly why the case is brought forward. is to say the calculation is different. And in that,
No, I mean,
I understand.
if it had happened that way, there would
be an argument
there'd be no way that somebody would say, oh, yeah, that first month is not excludable, right?
Yeah, but
Or-
yes, there'd
or
be an argument
is.
that
Sorry, I
30
keep getting it
seconds
confused, but is it, yeah.
is excludable, but there wouldn't be an argument that the whole month is excludable.
Okay, so
And I think there's,
if that's true, then, I mean, he says, look, what's the difference between that situation and the situation we have here?
in both situations, defense counsel has the opportunity to make the formal objection on the record and say, I object to this continuance. There's many reasons why a defendant might assent to
So
it.
your position would be, even if it was done sort of serially in the same hearing, the first month would be excludable?
No, the time between the initial request and the second request, so the hour and a half, which wouldn't amount to a day, so it wouldn't be counted. But yes, I think there is the case law is clear that the defendant has an obligation to lodge the objection. I get the defendant is now on appeal, labeling it as a professional courtesy, but the rule specifically avoids that kind of backward-looking thinking.
When you say that, do you have a case law that talks about, or have you identified any case law about going back and saying, in retrospect, let's view the situation. If this had happened, then things would be different. Is there any case law that you can identify where the analysis is done in that manner?
No, sorry, I might not be clear. I'm viewing it in the reverse, that the case law, and I think it's Graham I cited for this proposition, specifically avoids that kind of thinking and says once it's part of the automatically excludable periods, that's it. We don't
go back.
We don't go back and inquire. He had an obligation to object. No objection was made. It's under 3B, V, 3 little I or whatever it is. Sorry. And so we automatically exclude it once it falls under that 36B period, and then we don't look back into the rationale for why an objection wasn't made. And I believe I cited in the brief to the Graham case for that proposition.
Do you want to try to make the argument for how the last piece involving the motion to suppress is not excludable? Or, is excludable? You want to try to make that argument?
So for January 10th, I labeled it as January 10th to March 12th, 2020. For the motion, the motion is filed on January 10th. The parties appear on the previously scheduled trial date on January 20th. At that point, it's moved out. The hearing is moved out to March 12th. That portion of time, at a minimum, the period from January 28th, 2020 to March 12th, 2020 is excluded because it was the judge specifically waived Rule 36 on the record, and the defense counsel did not object. I think that's again an acquiescence.
Really, even if the judge was unaware at the time that the reason that the motion was filed was because mandatory discovery that should have been produced had not been produced.
And yes, and I think the Taylor case and the DeRicco case later is clear that the party is obligated to file a motion to compel in the Rule 36 realm.
But what about under circumstances where they have no reason to file one? What's the reason why the defendant should have filed a motion to compel? They didn't know there was a search warrant.
I'm sorry. As a
They didn't-
factual matter, the Judge Fabry and Judge Fabry is clear, and I think the police report was not included, but the fact of the search warrant is included in the initial police report. And so for purposes of this rationale of like, was the parties aware, was the party not aware, the search warrant was apparent.
I'm sorry, so in the initial, and this was disclosed, in the police report, there is a reference to the search warrant for taking the blood?
And that is based on a finding by Justice Fabry on, I believe, Record Appendix 67. He did that in the context of Rule 14 for saying there's no obligation because at the motion to suppress, at the sanctions hearing, the Commonwealth had made the argument that defense counsel was perfectly aware, so there should be no sanctions. And he said then the judge ruled that in the Rule 14 context, that's an inappropriate argument because they had no obligation to obtain mandatory discovery for themselves. But it does imply that defense counsel was perfectly aware that the search warrant existed.
Oh, wait, I'm a little confused. You're relying on the judge's order and not on the police report itself that's in the record?
Correct, because I don't...
Is the police report in the record, and does it
Police report
reference...
is not in the record.
Okay.
But I think for those purposes, at a minimum on January 28th, the defendant is aware that a search warrant exists. At that time, the Commonwealth states there is a search warrant. We haven't turned it over yet. At that time, the defense counsel is perfectly capable of saying, oh, there was a search warrant. That obviates the need for my motion and to withdraw the motion. Instead, the defendant
So it
agreed.
wouldn't be appropriate for defense counsel, first learning of the fact that there is a search warrant that was supposed to be produced in mandatory discovery, to actually wait until they received it?
Correct. And there are many reasons why they would still want to bring the motion to suppress forward, which is why the motion to compel is necessary and why Taylor and DeRicco require it. It's once they filed the motion to compel, and a motion to compel could have been filed on the 28th or the 10th or whenever. Once that motion to compel is filed, the time is told, and then the defendant need not have both count against him. And so I think it's an easy mechanism to alert the court and the prosecution that a piece of discovery, mandatory discovery, is missing, and all the time will be included until that discovery is turned over. I think here, had the defendant availed himself of just filing a motion to compel on the 28th, yes, all that time would be included, but without that triggering event, the time under Taylor and DeRicco, that time is still excluded.
You say that should have been done on January 28th.
At a minimum.
I want to, if I may, move you back to the second period of time, not to the third period of time, in which you argue that the motion to dismiss based on the quote-unquote no fix statute was taken under advisement. Would you agree that if you read the transcript of the judge's comments that day, that Judge Guzman basically says you can bring this forward if you have additional case law, but there was nothing taken under advisement at that time?
That is correct, Your Honor, and I would concede that period of October 10th to November 8th. Upon review of this, it is
Okay,
clear
great.
that the judge is inviting
That's
essentially a
that's
motion
a good
for
thing to tell us
reconsideration.
right from the get-go. When you
Sorry,
come to
I
argue.
should have
All
led
right,
with
so if, that's an important concession. Appreciate that.
Yes, I interpreted that as more adversarial in my initial
Okay.
review
well,
than upon.
It does conflict with the docket entry, which
Yes.
would have caused a problem. All right. So no need for remand on that particular period. If hypothetically, does not appear to be that we need a remand on that. All right.
And if there are no further questions, I would rest on my brief.
No, none here? No. Nope. Thank you both very much.
Thank you, Your Honor.
Okay, the second case on our list is Commonwealth versus Fernando, Ajuar, 2022-0535.
Good morning, Your Honors, and may it please this honorable court. Todd Pomelo, along with co-counsel Michael Kaplan, here today on behalf of Fernando Aguiar, whose motion to vacate plea and order to trial was improperly denied. At issue here is a fairly straightforward Padilla v. Kentucky case and its prodigy, in particular the Lavranenko case.
I'm going to interrupt you and ask you to lean a little bit forward towards the microphone. Don't hear you quite as clearly as I think I could. Thank you.
I'll try to speak up. My apologies. I'm a little over the weather. I had a
I'm-
cold, but
I'm sorry for you, but okay.
I'm doing better than Aaron Rodgers today. So the point I was trying to make is that Lavranenko, Padilla, the cases cited in our brief, at a minimum would have required the court to allow this motion. But what happened here, and it's not uncommon, is when you try to do these motions, the best you could ever hope for is for ICE to have your client into court. It got to the point 5 years ago where Judge Saris had to issue an order and there was a settlement agreement where ICE finally said they'd start transporting clients to court. What happens, though, a lot of times is clients will get held in Stratford County, New Hampshire, outside of the jurisdiction of that court order. So we tried numerous times to get our client habed into court. The first time he's not habed in, but the defense counsel's there, plea counsel's there ready to testify. Case gets continued another occasion. There's court congestion. So after 4 attempts to have the hearing, the defense counsel winds up in the hospital the night before. On the prior hearing, when the defense counsel was present.
Big problem for you because the judge rejects the defense attorney's affidavit.
Well,
right?
it's not necessarily the case. What happens is, at the hearing, the third hearing, when defense counsel is present, ready to testify, ICE doesn't have our client in. Our client was willing to waive his appearance and do the hearing. The judge refused to do so. He schedules it again for another hearing. At that hearing, the night before, we learned
Right.
that morning we learned that the defense counsel was in the hospital. He didn't show up on the subpoena.
So you started off the top with, this is a fairly straightforward Padilla case. At a minimum, we should be granting it. But now all of a sudden, we're into a whole discussion of scheduling. What are we supposed to do with that? I mean, aren't we stuck with the record that was created?
Well, respectfully, Your Honor, it is straightforward in the following circumstance. When it is brought to the court's attention that defense counsel is in the hospital, the judge doesn't say anything, the Commonwealth doesn't say that it wishes to cross-examine him. We have his affidavit. His affidavit essentially admits to violating Padilla and Lavranenko and all the other cases. And the judge never makes an issue of it, neither does the Commonwealth. After two witnesses testify, like our client testifies at length, so does his daughter, who was the victim in the case. When it's time to discuss the affidavit, Attorney Kaplan offers it in evidence. There's no objection. At a minimum, under the rules of evidence, it should have come in de bene. Commonwealth never files a motion to strike, never objects whatsoever, and then there's argument.
So the affidavit is in,
Yeah.
but the judge rejects the affidavit on the merits, doesn't he? Doesn't he say, not detailed enough for me to reach the conclusion that you just said, which is, and I understand this is one piece of the core of your argument, that the attorney, quote, essentially admitted to violating Padilla.
Correct.
What is it about what the attorney said that gets you there in light of what the judge says, which is not detailed enough?
Well, unlike other cases, the judge doesn't discredit the affidavit as being, for example, self-serving or saying, I don't believe this attorney. Sometimes judges will say things like, I'm familiar with this attorney's argued Padilla motions himself, and now he's claiming that he didn't advise the client about immigration. This affidavit, in many respects, is better than the affidavit cited in the Lavranenko case. Lavranenko's attorney said he didn't recall doing certain things.
It was, but not to interrupt you, the judge actually says, and I'm quoting, the court gives no weight to plea counsel's affidavit in determining whether he gave ineffective advice to the defendant.
Because the Commonwealth didn't have an opportunity to cross-examine him, not because he discredited it for other purposes.
Well,
And the Commonwealth had an
actually,
opportunity.
that's one interpretation. That's one interpretation. But then the judge goes on to say exactly what Justice Englander has mentioned. He goes on to say the affidavit is not detailed and is otherwise inadequate and fails to allow the court to make findings of fact on the central issue. After that, he says, moreover, the affidavit can't be challenged by the Commonwealth.
Right.
So let's just say we agree with you and we excise that. You know, the Commonwealth didn't object to what was going on that day. The Commonwealth was willing to accept the affidavit. Even if we were to accept that argument, what do we do with the fact that the judge has said flat out, he gives no weight to plea counsel's affidavit?
Well, he explains why he gives it no weight, and that is, I think, a legal error. He gives it no weight because he says it's not detailed. It is detailed. It
Well,
says
how
all
is
I
it
did was
detailed?
read the tender of plea form. I was not aware this is an aggravated felony. I was not aware that a one-year
Does he say that? I was not aware this was an aggravated felony? Where
He
does he
advised the defendant it was an aggravated felony. He wasn't aware that the
whoa,
one-year sentence
whoa.
triggered lifetime deportation.
Going a little fast, going a little
Yeah,
bit
you're
fast.
going really
Just
fast.
slow
and then
down a little bit for us.
This was the first half of the question I asked you. I got it in front of me. Where does he say, I did not know it was an aggravated felony? I was not aware of the grave penalties he would inevitably face as a result. That he says that. Well, that's kind of interesting because that could mean I wasn't aware that they were actually going to try to deport him. Doesn't necessarily mean I was not aware of the consequences of him pleading and taking a sentence of longer than a year.
All right, so paragraph 7 says that we had a discussion in which he was told a prison sentence of at least 365 days on count 1 made this an aggravated felony, and it subjected him to severe consequences. He was not aware of the grave penalties he would inevitably face as a result. I think those two paragraphs taken in tandem there's no discussion about aggravated felony. And then he goes on further to say, even with his years of experience in practicing in these courts, had he known that the 1 year, this is a split sentence.
Yeah, I see it in paragraph 10. Okay.
This is like a split sentence where
No, I think it's
Commonwealth
there in
thinks he gets a
paragraph
good
10.
deal. He gets a good deal because he gets out of jail that day. He spent well over a year in ICE custody after this, and has been deported from the country.
Yeah.
So is this really a good deal at all? This is a situation where even the attorney is acknowledging that had he known this then and had he advised the client accordingly, you have two things at issue. One is, could there have been a reasonable probability of a different plea? I would respectfully suggest the attorney is saying he could. And if the judge harbored any doubt about that, it should have been an evidentiary hearing. Frankly, this is a...
I mean, he should have waited to have defense counsel.
Yeah, reopen the hearing or allow the,
Did anyone
not
ask
mention
him
at all
to?
any concerns and then to...
Was he asked to reopen the hearing?
No, he was
So
not.
that
He
Attorney Hero could...
denied the motion. And time is of the essence. We filed the appeal.
I know. Let me ask you this, because I think it might be fair to say that another judge might look at that affidavit and consider it detailed, right?
Correct.
But we look at
Well-
this at abuse of discretion. So is that enough to say that this judge's interpretation or consideration of that affidavit is beyond what any reasonable judge would do in these circumstances?
I say respectfully, Your Honor, he did if you look at it an abuse of discretion standard, he did abuse his discretion. But is it necessarily a factual question, or is it a mixed question of fact and law? Because you have other affidavits, like the Lavranenko affidavit that's discussed. Nearly the entire affidavit is in that case. And that affidavit has less detail, I would respectfully suggest, than this one. That attorney didn't recall doing certain things. He said basically if his clients would tell them they weren't citizens, he'd read them the green sheet. Whereas here, the defense counsel states that he knew he was a lawful permanent resident, and all he did was read the green sheet.
Well, what about the fact that the judge here was concerned, this is a little bit of a different situation, that this defense counsel had represented your client for 15 years or so, and had represented him in other instances of cases that might have triggered deportation, or could have, or qualifying offenses for in terms of the deportation statute,
Yes.
right? And he didn't know, the judge was not informed about any of those conversations, or what kind of rapport, or what kind of advice had been given in those other times, and relied on that in part as well. Does that distinguish this case at all from the other cases?
Slightly, but I think, again, it's contextual. I would respectfully suggest, again, that's something that could have been explored at an evidentiary hearing. But if the attorney a few years ago is not giving proper immigration advice, and he's had the same lawyer for years, and he's never been arrested, he's never been placed in immigration proceedings, he thought lawful permanent resident, it's a misnomer. You have permanent residency, but it's not really permanent. You
No,
can lose it.
it is a
He testified that he thought it was
misnomer.
permanent because nothing had ever happened to him since the age of 2. He came here at 2 years old. He's 48 years old with a green card. And the judge, I mean, respectfully, I think this rises to the level of a due process violation, where you allow an affidavit in evidence, there's no objection, no concern is expressed whatsoever about the affidavit.
You're essentially
And you use it as
saying
a
that the
basis
judge,
for denying a motion when the lawyer's in the hospital.
you're essentially saying that the judge should have accepted the affidavit for the truth of matters asserted, because there was no objection to it, and because the attorney, who had been present on 2 prior occasions, was not present on this occasion only for good reason, because he was unfortunately hospitalized.
Yes, you're correct, Your Honor, and I think
That's what
respectfully,
is that what you're saying essentially?
Yes.
Okay.
And if you look at the affidavit at its whole, all he does is reads the tender of plea form, and that tender of plea form has been rejected by the SJC. The Petit Home case, which we've discussed in our brief, said that it's a misleading warning when the court gives it. So if it's a misleading warning for a court to give to every non-citizen defendant that appears before it, if your lawyer is also repeating the same warning to you, which the case law says is not advice, page 54 of Lavranenko says that, you're doubly misled. You're misled by the court and your lawyer. And again, I'm sorry about a little bit of a cold, but brings me to something I noticed. I'm taking a Zyrtec last night, 12-hour Zyrtec, to get ready for oral argument. And on it, it says it may cause drowsiness, it may cause anxiety, it may cause an assortment of other issues. But it also warns you not to take it if you have certain pre-existing conditions and to consult your doctor. And if I called my doctor and he read me the same thing on the box, I would hardly think he gave me medical advice. He's supposed to inquire, do you have those pre-existing conditions, and give you advice that you shouldn't or should or should not be taking this medication.
Well, that argument goes to what I think is a very difficult question in these cases, which is to what extent does defense counsel have to be an immigration attorney? And I'm still struggling with that. But let me ask you a different question. Let's just get past for a moment the question of adequacy of the advice and go to prejudice.
Yes.
Don't you have a problem where your client was deportable already? Why not?
Lavranenko again. Lavranenko was separately deportable for 2 or more crimes involving moral turpitude, and Chief Justice Gantz's opinion goes at length about how preserving the right for discretionary relief in the immigration court, if not failure to do so.
But here it wasn't discretionary, right? He had an ABDW from 1995 or 1998.
Which is not an aggravated felony. The court erred in that respect too, and we brought that up.
It's not an aggravated felony
correct.
Because?
The Windley case, because when, in order
Could be reckless, yeah.
analyze an aggravated felony in the immigration court, the burden's on DHS to prove by clear and convincing evidence it's an aggravated felony. And the statute allows for specific conduct and more generalized conduct. And there's no proof whatsoever in the record that it was the more specific version of an ADW.
Okay, but...
And it's conjecture at best to say it's an aggravated felony.
I understand this only part way. So, first of all, you're relying on some First Circuit case, right, which talks about what assault and battery with a dangerous weapon is under Massachusetts law and whether recklessness is sufficient, right? Is that what, am I on the same page with you about this?
Yes, and it's based
Okay.
off of U.S. versus Johnson, a Supreme Court case.
So what you're saying is, as I understand I'm not even sure I do understand the argument, but I think it's along these lines. It is true, yes, that this particular defendant had previously been convicted of assault and battery with a dangerous weapon, and if that had been intentional, he would have been automatically deportable already, and therefore what happened with the strangulation would not have mattered. But we don't know on this record whether that was intentional or reckless. Am I...
You can't discern from the record of conviction that it would be the intentional version that would make it an aggravated felony, because so the reason First Circuit
But
case...
am I right that someone could? In other words, am I right that if the federal government had chosen to deport your client on the basis of the, I can't remember whether it was 1995 or 1998, but one of those two convictions, that they could have proven that it was an intentional ABDW by putting in facts associated with that prior crime?
Respectfully, they would not have been able to prove it because they're limited to the record of conviction. And the record of conviction only consists of the indictment or complaint, the tender of plea form, the colloquy, and the statute.
Okay.
And that's that issue. And then they look to jury
and I'm
instructions.
familiar with this issue. You may know that I'm familiar with this issue because I've looked at it in another context. If the tender of plea indicated facts which indicated intentionality, wouldn't that be sufficient?
It would be if it indicated that, but the Massachusetts statute doesn't require it.
Doesn't require it.
Divisible
So but the
statute.
federal government could go and find it. I mean, the problem I have is that I don't know what to do with this.
Permission to answer?
Of
course. I have one idea, respectfully, Your Honor, is if the court's not inclined to allow the motion for new trial on appeal, one remedy would be a remand for the court to explore that issue, because that came up during an argument. The court said this is an aggravated felony, and we respectfully said it was not. He required briefing on a prior occasion. He wanted a supplemental brief, because the original motion was done on an emergency basis because our client was on the verge of, he just got arrested, he was getting close to being deported. So when we filed it, rather than ordering an evidentiary hearing, the judge basically denied it without prejudice, but then issued an order requiring all these additional arguments to be raised in a supplemental memo. Commonwealth offered no evidence it was an aggravated felony other than an argument unsupported by case law. The judge's decision has no case law in it whatsoever. He just says this is an aggravated felony. Respectfully, it isn't. It's not, because the federal government is limited to how it can prove aggravated felonies. And the reason the First Circuit cases are cited is our client's deported out of the First Circuit. And again, back to Lavranenko. Lavranenko has a discussion in there at some point where it said when he pleaded to those prior crimes involving moral turpitude, there was some ambiguity at the time whether it was a crime involving moral turpitude. But then the matter of Jean case came out, which made it a violent
Moral turpitude is different because it's never
made it
automatic.
Conduct. So there was some ambiguity even then with the case law in the immigration context.
Justice Engler has another question.
Just one more. This is a quickie. I assume your client is still in the United States?
No, he was deported over the summer. But he's a lawful permanent resident, so what would happen if this motion were allowed eventually is we'd have to file a motion to reopen his proceedings with the Board of Immigration Appeals and then go through a visa processing where he gets returned to the United States, because if you're a lawful permanent resident and your immigration case is reopened, which means the deportation or the removal order is voided, you revert back to the status you previously held. So his status wasn't undocumented. His status was a person who had a green card since the age of 2 years old.
Mm-hmm.
So he would...
That was a long way of saying, this case is not moot.
Correct.
Okay, thank you.
Thank
Thank you,
you.
Your Honor. I appreciate it. I rest on the brief.
Thank you very much. Commonwealth.
Good morning. May it please the court. Julianne Campbell on behalf of the Commonwealth. I respect my brother's argument, but I point out that it is the defendant's burden at a motion to vacate his plea to demonstrate, first, that he received ineffective assistance of counsel, and second, that he was prejudiced by that purported ineffective assistance. This record, my brother contends, compel the motion judge to allow the motion. And I respectfully suggest that is not the case. This judge did not err in denying the motion after an evidentiary hearing in which he heard from the defendant, he heard from the alleged victim in this case, he looked at a significant amount of records, including the defendant's plea counsel's affidavit. And
With respect to the affidavit, the judge seems to say a number of things that, in my view, seem to be at odds with one another. One is, I give no weight, so I'm sort of disregarding.
Sure.
To me, that sounds like I'm disregarding the affidavit. But then at other points, sort of considers the affidavit.
sure. So
What do you make of that?
So my understanding, and I considered that in context of the order and rulings as a whole, the judge also, despite finding that there was no error or no ineffective assistance rendered, he then goes on to find, even if otherwise, I find no prejudice for these reasons. So in my assessment, my interpretation of the judge's ruling is that he gave no weight to the affidavit. However, even if he were to do so, it's still insufficient.
First of all, do you agree that, is it appropriate for a judge to give no weight to an affidavit because the other side doesn't have an opportunity to cross-examine when there was no objection on that basis from the other
Sure.
side?
So I think where there's no objection, certainly the court is required to accept it as evidence. That does not mean that a court is required to credit every word in that
Some
affidavit.
weight should be given to it. What, negative, positive, it should be considered.
And I think the judge's ruling as a whole suggests that even if he considered it, I think that, and that's what I was trying to speak to. I'm not trying to talk in circles, but where the judge says, I give it no weight, however, and explains, frankly, reasonable reasons, not only, well, the Commonwealth didn't object, but that this was his counsel for 15 years. This counsel isn't detailed in this affidavit about what he did or did not say, although
Yeah,
he does.
but you know, I just read paragraph 10 and I'm troubled.
So
Paragraph 10 says, if I had known that a sentence of fewer than 365 days on count one would have prevented any immigration consequences for my client, I am confident I would have been able to negotiate a plea. I read that to say, I didn't know that if he came in under a year, it was a different situation for him in immigration. Isn't that malpractice?
no.
Just a moment, and to add on, he even says that he could have increased time on one of the other.
Certainly. So I have a two-part answer that I would, if the court would grant me the room to do that. So under the first part, I don't think that that is malpractice under the law, because under Padilla and under the SJC's guidance in De Jesus at 181 of that opinion, competent counsel must convey that if federal authorities apprehended the defendant, that deportation would be practically inevitable. That is the language that counsel was required to put his client on notice of, and that is the language that counsel avers in his affidavit that he provided. That's what the case law says.
So I hear you, but I have a problem with that.
And if I could answer the second part, I'm happy to take the court's question, Your Honor, but I think it addresses the concern about the lesser time, because this is another reason the judge was within his discretion to not credit this affidavit, because I am not aware of a single case that permits the Commonwealth to consider a defendant's nation of origin in crafting a sentence a specific way.
Okay, I'm good with that. I get you. I get you on where you're headed, but this is the problem I have. I'm defense counsel. I have someone who I'm pleading. If I can plead him to less than a year, he's not deportable for that reason. If I plead him for more than a year, he is. I plead him for more than a year. Haven't I committed malpractice if I did not know?
No, because what the
Why not?
because what the case law requires under De Jesus is that counsel
But he's always required, I mean, the fundamental question is adequacy of counsel. So forget about, what De Jesus and everything else says. I'm his lawyer. I should know, I had him for 15 years, that he's not a resident, he's not a citizen of the United States. And I should know, and here's the part where I get, if the law says you should know that the immigration consequences of a plea of greater than a year are automatic deportation, then I think then, as the lawyer, you have to do what you can to bring him in under a year.
I don't know
and he's
what
saying,
case
I
says
didn't know.
that, Your Honor. I don't know what case says I have to know as reasonably fallible criminal defense attorney that they must know if sentenced over a year will trigger deportation.
I think Lavranenko says that in that footnote.
I respectfully disagree with that interpretation.
I mean, I hear you on this, and I think it's a real issue. But I think what the cases say is if it's, even Padilla suggests it, if it's clear, if the immigration consequences are clear, the defense lawyer needs to know it. Isn't that what they say?
Your Honor, sure, but it is, I would suggest that this is not clear because and I can only speak to my own abilities in trying to understand the immigration statute as I'm trying to prepare for this court. And Your Honor, I consider myself competent prosecution, but it is a labyrinth of complicated laws.
Then shouldn't you get an immigration lawyer involved? Isn't that what Lavranenko's footnote says?
Your Honor, but criminal counsel here advised his client he was practically inevitable if the federal authorities sought his removal, that he would be deported. And counsel is arguing that it was an abuse of discretion for the motion judge to not credit every word of plea counsel's affidavit. The defendant is the one with the burden at this stage. The defendant did not ask, Judge, if you're not satisfied, I'm happy to bring it back. He didn't file a motion for reconsideration on those grounds, and he certainly did not move to reopen the hearing. The defendant failed to meet his burden, and the defendant's own testimony acknowledges that his client, that he was advised by his attorney about the types of warnings on the back of the green sheet. And so, quite simply, under the first prong, the defendant didn't satisfy his burden, but even if we move to the second, there is no prejudice here, because the defendant could not satisfy any one of the three ways in which one establishes prejudice.
His lawyer says, had I known that if I brought him in under 365 days, he's okay, I would have been able to negotiate that plea. Isn't that enough?
No, Your Honor.
Why not? Doesn't that...
Because as a prosecutor, I am not aware of a case in this Commonwealth or in this country that permits me to consider someone's nation of origin.
But that's not the point. See, you're thinking of
because-
it, may I? You're thinking of from the context of, you're negotiating a plea, you're thinking of the context of the defense lawyer comes to you and says, I need you to go under 1 year because. But suppose he comes to you and he says, look, why don't we do 11 months on this one? We'll do 14 months on this one. And he says, I'm confident I could have gotten that.
Your Honor, I would suggest...
He never mentions the immigration consequences to the prosecutor.
Your
He
Honor,
simply brings it in under 1 year.
I would suggest that the speculation of plea counsel in an affidavit that he would have or could have or should have tried to do that is not sufficient to demonstrate that the defendant was likely to achieve a better plea deal, especially this defendant with this significant criminal record of convictions in this country for a range of violent offenses, operating under the influence, and then on this charge...
It's plausible to me, because whether it was an 18-month suspended sentence or an 11-month suspended sentence, it was going to be a suspended sentence. He was going to be let walk that day.
Your Honor, I would suggest that that was prior to trial, Your Honor, and I would suggest that he had been held for 60 days under 58A. The Commonwealth was answering ready for trial for a strangulation, a crime of high lethality for a defendant who was found too dangerous to be released under conditions that would assure the safety of his victim, who was his adult child.
But then they did it.
Yeah. You mean he walked out that day?
Yes, because of the conditions and the plea that was reached that day, but that does not mean, and by all accounts, the defendant himself felt he had a good deal. That does not mean, and plea counsel's averment in an affidavit should not suffice to demonstrate that the defendant would have gotten a better
I think the point
deal.
is that few people, I think few people would say that this was not a good deal. I mean, he walked out after only 60 days, and there was a very serious case, and it was apparently also on videotape. So even if his daughter was reluctant to testify, the Commonwealth had evidence. But it wasn't a good deal for him if we accept the fact, which the judge rejected, if we accept the fact that he didn't know that that meant he was going to be deported. Do you see what I'm saying? So there's a difference there.
I do, but I'm at a loss because if Your Honor is speaking to the third set of special circumstances, I'm again constrained by the record, which does not speak to the defendant's employment history, which does not speak to whether he has minor children who are dependent on him, which does not speak.
He testified to that. Judge asked.
Minors, not to dependence on him, or when he last saw his wife. We know nothing about these things because the defendant did not put them in evidence.
Right, but the second prong, I get your point on 1, I get your point on 3, I don't get your point on 2 necessarily. The second prong is, could he reasonably have negotiated a deal that would have avoided the immigration consequences?
And I would suggest that given the strength of this case, given this defendant's extensive criminal history, given the facts of this case, which are strangulation and obstruction of someone's ability to breathe, given that the Commonwealth considered him such a danger that they moved for a 58A, and given that this was recorded on video, evidently, according to the transcripts, I would suggest it is not likely he would have gotten a better deal than this.
What do you
walking out
say
that day.
to their argument that he was not immediately and mandatorily deportable as a result of his prior ABDW because we don't know whether it was reckless?
So I think that part of this is a little bit of a red herring. I'm not relying on it, candidly, Your Honor, that he was otherwise previously rendered deportable. I'm not confident that the judge was correct about that. Again, I'm speaking to my own limitations in trying to understand immigration law. That's where I come down on it, and I'm not asking this court to affirm it on that basis. I'm asking this court to affirm it because I don't believe the judge abused his discretion in declining to credit the affidavit, and I would suggest the defendant failed to meet his burden with respect to prejudice.
But on the prejudice element, you're not relying on the fact that the judge's determination that he was previously deportable. With
No.
prejudice, you're relying on what?
I'm sorry, can you?
With respect to the prejudice argument.
Yeah, so my three, with respect, I'd suggest there's no indication that he had a stronger defense available, that he could have succeeded at trial. I would suggest that there is no evidence a better deal was available to him. I think
Except counsel's affidavit.
which I would suggest the judge did not abuse his discretion in declining to credit.
Do we know that he declined to credit that?
No, he doesn't specify by the
specific-
paragraph, no.
Right. So we don't know that the judge specifically discredited that statement, that I probably could have worked out a better deal, specifically laying out how he would have worked it out.
I actually think the judge does, because I think in his rulings of law, when he goes on to evaluate prejudice, I believe he actually addresses the second prong and says that I do not find, I would defer to his rulings, but I am confident that he addresses that second prong of prejudice in his decision. And again, I would suggest that this testimony as put forth by the defendant with respect to the third prong of special circumstances was just wholly inadequate because it's conclusory in nature. There were not specific facts presented to the judge with respect to his ties to this community, other than that he had lived here for as long as he had lived here and had been a lawful permanent resident.
Humor me for a moment. What's the
Certainly.
exact language of the second prong? that it would,
The
that-
judge's language or?
no, the second prong of prejudice, they have to show that he reasonably, not only that a better plea was available, but that it would have been reasonable for the defendant to take that plea? Is that, are both elements of that?
Your Honor, if I could just have a moment to answer Your Honor's question. It's a reasonable probability that the defendant could have negotiated a plea bargain that did not include those dire immigration consequences.
Okay, thank you.
Seeing no further questions, I'm happy to rest my
No further questions. Thank you both very much. We'll take the case under advisement. Okay. The third case on our list today is Kamal versus Khalid Khalila, case number 2022-0817. Good morning.
Good morning, Your Honor. My name is J.W. Carney, Jr. I represent the appellant in this case. The only issue before the court is whether the trial judge made an error in denying my peremptory challenge of a juror.
Juror number 32.
Yes. Juror number 32 was an African-American juror, and the court purported to investigate my challenge pursuant to SOARS, which was appropriate. But the facts were, that are relevant to this, the juror's mother worked for the Boston police. It was the Boston police that investigated this case. And we were going to cross-examine the Boston police to determine if their investigation was adequate, where the chief officer, who was the first person on the scene, Captain Kachiko, never questioned anyone outside the place about what they had seen, and never even preserved evidence that normally would be saved, in this case, the glass. So with that in mind, I challenged this juror because his mother worked for the Boston police, and I was concerned that she would not look favorably on our cross-examination of the two Boston police officers. When a lawyer is questioned about the basis for his or her peremptory challenge, there are two questions that must be asked by the appellate court as well as by the trial judge. The first is,
I think we're pretty familiar. Why don't we cut to the chase for a moment? We can go back. What do we do with the statement by the trial judge on the motion to stay? And here I think I was saying, although it wasn't intended, he means although it wasn't intended by you, that the real reason was race.
What the judge was doing is just thinking out loud on the bench that there could have been a reason, even though he had said...
Wait, you're telling me that was happening with the quote I just gave you? Because I read this as being a fairly carefully considered, lengthy statement by the judge before he even heard argument.
I submit that his finding that my reason was genuine, which was repeated 4 times at the hearing, is what the court needs to rely on to find at this level that it was genuine.
So your argument then is that in deciding this case, we should reject the judge's statement that I think I was saying that the real reason was race.
That does not bear examination.
You mean, in other words, we should reject it?
Yes.
Okay.
Well, for 2 reasons, or just so I can be clear on what the reasons are. One reason could be because there's no basis for the judge to have found that. The second reason could be that the judge did not make this finding in connection with his ruling on the peremptory challenge. It was made much later in the context of a stay of execution of the sentence, determining whether or not the issue of the propriety of his ruling was one which was a meritorious issue on appeal. So are you saying that there was, or maybe you're saying both. One, it's not, there's no basis for it, and 2, whatever the judge said at that hearing, at the stay of execution of sentence, we should not be considering because it has nothing to do with his ruling on the peremptory challenge that happened at trial.
I'm advancing both arguments.
Yeah, okay.
And, it's unusual in my experience in this situation for a judge to say over and over and over again that, Mr. Carney, I find your challenge was genuine. In fact, look at the balance of the jury selection process. After juror 32 was seated, the final jury had 5 other people of color on it. I did not challenge any of those 5 people for cause, nor did I challenge any of them peremptorily. So that backs up his finding that my reason for challenging this juror was specific to this juror. The court has stated...
I'm sure you've looked, and I will confess that I have as well. But have you found any cases that address a circumstance where a judge's ruling subsequently, motion for new trial, motion to stay, has been rejected by an appellate court?
No, I have not found that. But I submit that this was his rumination about something that would get him out of the problem of this being reversible error because it was a structural error. So in that way, the court is trying to justify it, and he's changing now to an intentional, unconscious bias. That appears nowhere in any case law. It's a non sequitur. How can you have an intentional, unconscious bias? I mean, if that were allowed to remain, then a judge who wants to find that the defendant's peremptory challenge of a person of color would say, well, I know you think you're making this challenge because of a reason specific to this juror, but actually, I'm going to find that you engaged in unconscious bias, and that means the real reason you challenged the juror was because of race. That's going to completely destroy all of the case law that says you've got to look if the lawyer's challenge is genuine. That's the first question, and I submit that his original finding that my challenge was genuine was borne out. The second question the court has to determine is whether the lawyer's reason for the challenge was adequate. Excuse me? Quote, "An explanation is adequate if it's clear and reasonably specific, personal to the juror, and not based on the juror's group affiliation, and related to the particular case being tried." My reason for challenging the juror is that the Boston police did the investigation. We would be challenging the adequacy of that investigation.
And I know that that was actually part of the opening argument. It was the first thing that one of the first things that the jury heard, that there was going to be.
Sorry, it's not you, Your Honor, but for me, if you can speak a little
Sure,
louder.
I'd be happy to. And I know as well that that was part of the opening argument, that the Boston Police Department was going to, their actions were going to be challenged. But what do you say about the judge's comparison with the peremptory challenge on juror number 32 on those grounds that you've just articulated, with the grounds that were apparently could have been the basis of a peremptory challenge for juror number 17, who also had, I believe her father, if I'm correct, was a retired police officer. And now I'm not remembering, I don't believe the father had anything to do with the Boston Police Department, if I'm correct.
It's not on the Boston
Yeah.
police. My objection to juror 32 was specific to him.
Mm-hmm.
He was the only person who had a relative working at the Boston police. And because that police officer, or the two police officers, would be challenged about the adequacy of the investigation, which was done in cross-examination and repeated again in closing argument, I did not want someone whose mother worked for the Boston police. The juror that Your Honor is identifying, that juror's father was retired, but not from the Boston police.
How did you know that? Because I couldn't find that in the record. Someplace I saw a reference, I think by you, at the sentencing motion to the fact that he was retired from Vermont, but I didn't see that in the record.
I believe it was in the juror's form.
Questionnaire.
That was the questionnaire, because as the court knows, each juror is asked, do you have any connection to law enforcement?
So they
Whether
would have-
it's the police or,
The juror would have filled that out and might have, yeah.
right. And that's where we would have found out that the officer was retired from another state. I didn't find that to be an impediment here. And that's why I did not challenge that juror. The only challenge I made because of the familial connection was juror 32. And the court is familiar with the fact that there have been several cases that have examined this specific issue. Was an assertion of the familial relationship of the juror to the police department handling the case, is that an adequate reason? And I cited 3 cases where this court or the SJC has stated that is an adequate reason
Right.
to challenge a juror.
And the first case is Gonzalez. It was one of the first cases that you referred to, Commonwealth versus Gonzalez, right?
Could you say it again?
Commonwealth versus Gonzalez. That was a case that came out a few years ago here from this court, in which we said that it was, but in fact, in which we anticipated your argument in the sense that the issue there was, we said that the trial judge had really refused to let the defense counsel exercise a peremptory challenge and was really employing a for-cause standard rather than the peremptory challenge standard. But in that case, the juror had a lot more. The woman was worked as a security guard. She indicated during her voir dire that she wanted to become a police officer. There was more in the record with respect to why or on what basis, personal to her, that the defense counsel would want to exercise a peremptory challenge.
That's the situation in this case as well, I submit.
Well, there weren't very many questions about.
Sorry?
There weren't very many questions about his mother or what she did or how he would feel about that, right?
Wasn't necessary, in my opinion. I wasn't challenging the juror for cause. And I think Judge Raschuti misconstrued the peremptory challenge versus a challenge for cause, because a couple of times he said, after questioning a juror in greater detail,
Found the juror impartial.
The juror, says she can make a decision, and it's not going to be affected by X factor.
Well, you
And I find her-
brought that to the judge's attention. The judge was made aware of the fact that that was the defense point of view, that there was, before your time is up, could you remind me, please, I know that you indicated the final jury in this case, there was 5 people of color, but could you break down of them, how many of them were self-identified as male or female, as men or women in that? Do we have that information?
Yes, we do. I'll just need to check for a moment.
I can double-check the record. If you knew off the top of your head.
I don't find it in my notes.
I know it's in the record.
I
We'll find it.
suspect it was
Have it?
2 women,
I have questions.
4 men. All 4 were, all 6.
We'll find that, but actually, Justice Englander has some additional questions for you, so let's move on to
I
those.
apologize for this because I'm
problem.
going to take you down. I think I'd like to give you the opportunity to respond to this. I am concerned about something that I understand why you folks have not been, which is that this is supposedly structural error, not to allow a peremptory challenge, and that prejudice is irrelevant to the question. And I want to give you the opportunity to tell me if you had to show prejudice, whether you think you could have, and how you would have done that.
I could not.
Okay. All right.
And that's why in the early cases by the SJC confirming that an error made in denying a peremptory challenge is impossible for anyone to determine what the prejudice is. But when stacked up,
But ordinarily, you would have permit me, ordinarily, if the error is not of constitutional dimension, at least as far as I know, I don't see it in our cases, and I wouldn't think it would be. Ordinarily, you would be able to say something along the lines of, the evidence was so overwhelming that this error is not going to be something that's going to require us to reverse the verdict. And I don't know enough about, because I understand why people didn't brief this, but what was if you could in a paragraph, what was the defense that was being raised and presented to the jury?
that the defendant was acting in self-defense.
Okay, thank you.
I love to appear before an appellate court and answer questions, and but if you have no more, I will take my leave. Thank you.
Thank you very much.
Good morning. May it please the court. Darcy Jordan on behalf of the Commonwealth. I think if we just take a step back, I think my brother and I frame this issue very differently, and I think I agree with the trial judge in that he did not abuse his discretion in framing it as what it was, a disproportionate application of defendant's proffered reason. And case law is very consistent in that that can show discriminatory intent. That is, just like here, we have a relation with the law enforcement. That was not, the defense counsel did not challenge juror 17, but then did challenge.
Well, let me say, I'm not going to ask if you agree. I'm going to say that on the face of it, juror number 17 and juror number 32 posed different scenarios. One in which the most important thing is there was a direct correlation and relationship with the Boston PD. Boston PD pays the salary of juror 32's mother. In the other case, the father had already retired from law enforcement. This case was investigated by the Boston PD. How much closer can you get?
And if I may,
Yeah.
I too understand why that can be a distinguishing factor between the jurors. But when we look at what the judge's job is to do, actually all the parties' job is to get a jury that is not biased, right? Or the best possible jury that we can do in that short amount of time in impanelment to tease that out.
Well,
and
let's back up. Both parties, the Commonwealth and defense attorney, are advocates for their respective clients, and they are trying to get the best jury that will see the case their way within the confines of the Constitution to be sure that they're not discriminating against anybody. Correct?
Correct.
All right.
And I think...
I didn't hear you say it quite that way.
Well, I think at the end of the day, it's a short period of time, and I think we can all identify that impanelment is...
Goes quickly.
Right. There's broad strokes, again, within confinements, and I think what impanelment does is that when we're looking at law enforcement, it's a general bias that's trying to tease out law enforcement. Like the juror questionnaire just says, do you have any relation with law enforcement? It doesn't say with the prosecuting police department at issue here. So, for example, the juror questionnaire doesn't say, do you have any family members or relations on the Boston Police Department? Because the point is to fetter out any kind of bias about law enforcement, again, of course, within the confines.
It has another point, as Justice Vino was pointing out, not simply to have everybody agree on the best possible jurors, but to have jurors that may see things from their point of view. So it's not, and in this particular case, it's not a general bias against law enforcement, right?
Well,
you heard that articulated. It had to do with this case, which involves specifically the Boston Police.
Yes, but I think when we're looking at what the judge is doing, the exchange that he's having, what he looks at in this whole case that had deep racial overtones, the allegation that the N-word was used, that up front the judge is saying during, if we look at the transcript, even like in the logistics when he's talking to lawyers about placement of jurors, he's like, this is going to be a serious case that we're going to be really looking at race. And multiple times he's saying this is going to be something, basically giving it to the attorneys, I'm going to be scrutinizing impanelment very closely for any racial overtones. And I think here what Rashidi was doing was saying, I'm looking at law enforcement bias and a bigger scope, and I think that's what we want when we're doing impanelment. We don't want the narrow
I don't think anyone has
focus.
questioned, I didn't hear a defense counsel question at all, that the judge acted inappropriately by asking for a explanation. So that was correct. The issue is whether or not the explanation should have been accepted or not. So clearly, the judge here was exercising his appropriate role of trying to ferret out if any of the preemptive challenges were based on an improper motive. So asking the question was perfectly okay, but comparing the responses or comparing the conduct of defense counsel to what had happened with respect to other jurors, if they weren't exactly on par, could be questionable, as well as the kind of language that the judge used, pretty much indicating that he was concerned about impartiality when it wasn't a for-cause challenge. It was a peremptory challenge. So what do you say about that?
Well, I think what the judge was saying was that you are here saying it's law enforcement. And I understand the court's distinguishing between Boston police and not, and I understand that. But I think based on the record, the judge was saying you're using a relation to a police officer as your rationale, your proffered reason, and this is a black juror. And I see that we just had a juror had a family relation, and you didn't ask them any questions about that.
No. Defense counsel is not saying that. It's not law enforcement in general. Defense counsel is saying specifically, it's Boston PD.
Right,
It
and
could be General Electric, for example. It could be this incident happened down the street at the new General Electric headquarters, if there is one now, I'm not sure. And you could say something like, the potential juror's mother works at GE.
Right.
I don't want anyone to
Right.
do with GE on this juror.
I understand your point. I just think that that is a too narrow focus
Okay.
when we're looking at bias and impanelment. And I think what the judge was saying was that I'm looking at this more broadly. I understand you have a relation, and I think later, as the court was saying,
What does that mean? He's looking at it more broadly.
he's looking for bias about law enforcement. Is this person's...
Okay, but he specifically found, I have a concern that the judge's discussion, which occurs at sentencing, which includes that sentence that says, I think it was based on race, seems to me to be trying to confuse something. That's the wrong way to say it. Seems to me to muddy something that shouldn't be muddied. The first question is the reason given to me genuine? The reason it was given is his mother works for the Boston police. The judge says, I find it to be genuine.
Right.
Isn't that the end of that question? How do you get to race when he says, Judge, the reason is he works for the Boston police. Judge says, I find it to be genuine. How can we get behind that?
So bear with me here. I think part of the language, the case law that talks about the genuine factor, it says it reflects the party's actual thinking. And I think based on, the trial judge's more broad understanding of the bias that he was trying to tease out, I think he was saying, I think that reflects your actual thinking, counsel. Like, I think you are giving me, and again, the language is, in the case law, is bona fide. So I think he's saying, I think you're being candid, but I think it's veiling an unintended race. And
So that last piece is not stated at all when the veneer is being examined.
So when you mean
That
not
last
this,
piece appears months later,
right?
or
So
weeks later.
So what is said at the?
A bit later.
So frankly, I think we can probably agree that in the context of the stay, that's talking about the first issue in the stay, I think what he's trying to do is clarify it for the panel here, what his thinking was. So I think.
And how do we accept that? Judges don't get to explain their thinking later on for us to consider. They make rulings of law and findings of fact. Maybe in a motion for new trial, that could happen, that a judge can give a little more, put a little more meat on the bone, so to speak. But I know I'm asking a slightly different question, but how do we accept what he said at the motion for a stay of execution of sentence? His explanation with respect to what he was actually really doing. Can we accept that?
So I think I think you could consider it as much as it's fleshing out the original point made in the transcript. And I'm going to go to the transcript right now, because I think that if you will, the bones, the findings that this court can rely on are present upon the.
You're going to go to the transcript from the jury questioning?
Yes, from the.
I'd like to hear what you rely on.
Sure. So it's page. It kind of starts at 157 through. And it ends on 161, and this is all definitely in my brief, but at some point, this is where I think Justice Rwanda was talking about. I'm challenging defense counsel, so I'm challenging with a preemptory challenge for that. As long as I have a basis that's real, I can use a preemptory. And the court says, unless I find it is not adequate. And then they talk a little bit more, and then the defense attorney says, I have a very specific reason, and the court says, well, that's true, I'm not challenging your genuineness. And then
Where was that?
that was page 160, and he says, in order for me to find this challenge doesn't violate SOARs, it must be both adequate and genuine. And I find your reason is genuine. I do not find it's adequate. And I think what really we're getting at is how this judge was struggling with implicit bias in the rubric that already exists in law. Because when the case law talks about genuine, the words that used to describe what the genuine factor is, it says it reflects the party's actual thinking. And I think the trial judge here was saying, well, I believe the explanation he's giving me, he believes that to be true in his heart, that there's no racial overtones. So I believe that. But I don't think that's the real reason. And I think he's struggling because pretext, which again is based in the case law, pretext indicates an intentional veiling. And I think the trial judge was struggling because
I see this paragraph, and I had it already bracketed for exactly the reason you're identifying, but I have a significant difficulty as an appellate court as to how we do this. We have, as your opponent points out, multiple times, the reason is genuine. And then we have this paragraph, which is pretty vague. Must be clear and reasonably specific, personal to the juror, not based on the juror's group affiliation related to the particular case. I just don't see why a black individual has no hesitation about hearing the evidence from a Boston police officer should be challenged on this. I just don't see.
So what I think,
so you think that's him saying, I actually think you're doing it on race?
I think what he's saying is that I believe that you are saying what you believe. I do not think you're being intentionally biased, but when I look at your proffered reason, again, the more narrowed interpretation that I'm proposing, that you didn't imply that same rationale to juror 17, the white juror. And then this language that Your Honor just encapsulated, it talks about adequacy. Now, in the adequacy explanation in case law, it talks about personal to this juror, right? And I think Your Honor was talking about 32, that reason being personal to juror 32. But I think what the judge, after saying, I believe him, so I've discarded of my analysis under the genuineness prong, but I still think there's disparate application of the rationale of law enforcement, and that means what he's saying is that explanation, law enforcement relationship, was not personal to juror 32 because juror 17 also had that same relationship, meaning it's not individualized now, this explanation given to 32, because it's also applicable, again, in the broader sense.
But if we were
to juror
reject
17.
that and say that the 32 was significantly different because of the ongoing relationship and the identity of the department itself, then that argument doesn't have the same force.
Sure, and I'm sorry.
I don't think defense counsel ever said when this was going on, hey, there's a difference between juror 17 and juror 32 because juror 32, their mom works for the Boston police.
I
Right?
agree.
I agree. That's also something that arrives later in our transcripts.
But I think actually, Your Honor, I think that's the nugget, though, because I think...
Didn't they say something right around page 170? Didn't it come up again? Wasn't there sort of a... I'm sorry to interrupt on the record, but Justice England may be entirely correct, but I recall...
Oh, that's a good question.
I recall that this came back up...
It did come back.
...with other jurors, and the Commonwealth exercised a peremptory, and defense counsel objected and said, why is it okay for this one peremptory to be okay, and you wouldn't let me exercise mine? And there was more of a conversation. That's around page 170, volume 1.
Is that in the second, I think that's the second transcript? Is that... I'm sorry.
No, I think it's day 1, volume 1. Yep, I have it right here.
Okay, I'm sorry. Can you give me the...
Page 170 and 171.
Of transcript 1?
Yes,
Okay.
volume 1.
Okay, I'm
Jury
with you.
trial,
I'm
jury trial day
there.
number 1. Jury
Got
trial
it.
day number 1.
I'm there. I got it. Okay. I'm just trying to recall that juror.
Counsel says, well, I don't remember Your Honor stating when you overruled my peremptory that the basis for that peremptory was racist. The court says, I didn't say, And then the defense counsel says, what you're doing is you're saying because this doesn't have a racist factor to it, that you can overrule or you cannot overrule her peremptory for the identical reason that you can sustain her peremptory despite the fact that it's the exact same reason that you overruled mine. Hard to read this a little bit out of context, I understand. But this is, of course, also, again, where the judge says that twice, 3 times, I found your reason genuine.
Right, and I think, again, looking at, I think in that case, that juror, I think, had a case in Suffolk County, and I think that was why that juror was exercised. And I do have, I'm sorry, I do have...
a case had been investigated, but I don't think it was a current case.
And I do have that same section highlighted, too. But I think what the judge was saying there is that when there was, his point was that it's different because there was what the trial judge understood to be 2 similarly situated jurors, one white, one black, and that the preemptory was only used on the black juror using the same rationale and not used on juror 17. And I think that is what the disparate application of the same proffered answered is.
Your time is up.
Oh, sorry.
I'm cutting you off because I just want an answer to 2 questions to be sure that I understand exactly your point of view. Am I correct in stating that you believe that the comments made by the judge at the hearing on the motion to stay execution of sentence, which occurred on June 11th, 2021, about 2 weeks after the defendant was sentenced, that we should look at that and rely on what he said about his ruling in the course of that hearing in determining whether or not he erred or did not err in precluding the peremptory challenge?
My answer.
Yeah.
I think you can look at it so much as it does inform at least his explanation, but I think the record reflects that, and I think nothing would have changed, I think, at the time, had those things been said
All right,
at
so that's
the
good. So you're
time.
saying so if we were to reject it, you're saying it doesn't matter?
I don't,
Oh.
I think so, because I think, again, when objections are made to trial judges, it's whether or not they can react, if you will, to fix it. And I think what we're discussing happened at the pivotal moment, if that
Last
makes
question,
sense.
do you know off the top of your head what the makeup was of the 5 people of color that were on the jury? And if you don't, we'll look it up. I don't want you to waste any of your time now.
Your Honor, I don't, I was looking for it, I believe it's in my brief. I was looking for it.
We'll find it, never
but,
mind.
I know it's in my
I'm already keeping you longer than
I'm going to keep them longer.
Go ahead. Justice Englander has another question.
I apologize, but I'm going to go down the same road that I went down with your opponent for a moment. I am sure that the Commonwealth would like the law to be that this is not immediately an automatically reversible error if the judge makes the wrong call on a peremptory challenge. But what would that look like? What would that look like? So, if you were in here, if the cases were, let's say, a little bit more careful about this, it's probably the wrong word too. The Commonwealth could come in and say, look, it was a peremptory challenge. This juror was seated. The juror was, even if the juror shouldn't have been seated, even if the peremptory was correctly asserted, you shouldn't reverse this because, how would you finish that sentence?
Because this was still a legally qualified juror, because
But that would mean never. That would mean the judge can make a mistake on peremptories and it doesn't matter ever. So I think that's a tough sell for me, okay? It's got to be more along the lines of other case law we have where a non-constitutional error is made by the court and we allow the case to stand.
Well, I think that was my next. This is a statutory right. This isn't a constitutional right.
Right.
So at the end of the day, prejudice would have to be established. And I don't know, I know going back to my original answer that you're not buying, but the fact of the matter is if it's a qualified juror, it's a qualified juror, meaning that the verdict would still be true or legally valid. So
Juror
I
is
don't.
not challengeable for cause. Everyone agrees a juror is not challengeable for cause. A juror could
Right.
sit. And so we don't have a problem there, but we have a mistake that's, this hypothetical world I'm creating, we have a mistake that was made.
Right, but I think
And then the Commonwealth would say what? That the evidence was so overwhelming that, is
Well,
that a case that could be made here?
Well, I don't know, but where my mind goes is that what are we talking about but the Sixth Amendment right to a fair jury trial? And I don't know how we get to...
Respectfully, I don't think we're talking about that. I think we're talking about a statutory thing that could exist or not exist in the whim of the legislature. So that's why I'm trying to figure out what the remedy, what in my hypothetical world the remedy really ought to be. Okay, I think where we are is a place that nobody can go because it's not in the briefs. Thanks.
All right, thank you.
Thank you both very much. We had lots of questions for the two of you. It's an important case, and we appreciate your candor in answering all of them.
Thank you.
May I cite to something, Your Honor?
One cite we'll take from you at this point. It's not what we usually do, but go ahead, sir.
It's the transcript of May 11th, 2021, at page 135.
Thank you.
The court notes that, including juror 32, the full jury had 5 other jurors of color, 2 women and 3 men.
Okay. Thank you. All right, so I'm going to call the next case, which is Commonwealth versus Lawrence Zinser, 2023-0104.
Good morning, and may it please the court. Rachel T. Rose for Lawrence Zinser. There's no getting away from the fact that my client's history is a bad one. But we're not here to decide whether it's safer to keep him in prison. We're here to look at the law. The hearing judge agreed that the 2 women whose parents' houses Zinser called weren't covered by probation's no-contact order. So the only question before this court is whether, without any existing protection order, making 3 unanswered phone calls to someone can be a felony if your past history with them is bad enough.
Wait, let me just back you up for a moment. Isn't the issue before us whether or not the judge abused his discretion in determining that the evidence established by a preponderance of the evidence that your client committed 2 new offenses, that is criminal harassment, one of them being based on 6 phone calls and one of them being based on 3 phone calls?
That's correct, Judge.
Okay.
And the answer to that is that it is automatically an abuse of discretion if they found him in violation based on a description of a crime that he committed that he didn't actually commit. If you find I believe it goes to the,
Can you just get a little bit closer to the microphone and maybe talk just a hair slower, because I'm having trouble picking everything up.
Sure. It would automatically be an abuse of discretion for him to find him in violation for committing this new crime, criminal harassment, if the judge, as we're positing, the judge used an incorrect definition of criminal harassment and said he committed it when he didn't. If finding someone...
Okay, so slowing down again, did the judge use the wrong standard? Did he misunderstand the elements of criminal harassment? Is that your point?
That is our point, yes.
Because you say that a phone call cannot possibly, under any circumstances, amount to an act, one of the 3 acts that's required under the statute of criminal harassment?
Well, yes, so the single missed call constituting an act of harassment, the reasonable person requirement is an additional part of the criminal statute that doesn't appear in the civil harassment statute. That statute says that violations of the criminal harassment statute qualify for civil harassment orders.
Can I just stop you for a moment? Do we have what the judge said in the record? Because we were unable to find it.
Yes, we do. It's in the our agreed-upon statement of facts, and then in the judge's supplement of the agreed-upon statement of facts. Here we are. Any reasonable person in similar circumstances...
Sorry, thank you. That was helpful. I remember now.
Okay, yes. The hearing judge's conclusion that Zinser's missed calls were harassing because anyone standing in the specific shoes of the victim would have been upset by them treats whether the act would seriously upset a reasonable person as the same question as whether the victim's subjective distress was reasonable. And that's what we're saying is wrong.
So you're saying the judge has eclipsed the objective element section. But I'm looking at Commonwealth versus Brennan, which apparently the judge relied on based on the reconstruction. And in that case, it seems to me that Justice Cipher says I think it was Justice Cipher, hold on a minute. Anyway, I believe I'm citing the right justice, was pretty clear on saying that a reasonable person in the shoes of the victim would have would have suffered substantial emotional distress.
So I think characterizing that as the shoes of the victim their entire life up until that point is where the problem is. The reasonable person in the shoes of the victim is, if taking some of the examples from some of the other cases recently, like Commonwealth v. Lehan, a stalking case from 2 years ago, Clemens, an earlier harassment case, they break out the innocuous or protected speech incidents of them coming up and hitting on you repeatedly, et cetera. They break out the things that the defendant did that anyone would find disturbing, grabbing their arm, vandalizing their car.
Right.
And they say that even though it's understandable that the victims are upset by all of it. So the shoes of the victim is the shoes of the victim as that particular act is being committed. Would I be upset if someone did this to me? Not if I was this person and had this history with the defendant, would I be upset? Because then you're second guessing what's in someone's mind.
No, I don't understand that. I think, as I was an author of Lehan, I think the question is reasonable in light of all the circumstances, right? In other words, was the behavior of the victim or the reaction of the victim reasonable in light of all the facts and circumstances known at the time?
Well, if you don't judge, that makes it very difficult to actually make the law make sense, though, because you have to, it means that what they actually did is irrelevant. You're looking only at who the people are, because if you hate me enough, then anything I do to you is harassing.
No, you're looking at both. You're looking at both, and it's not whether or not you hate me enough. It's whether or not the prior relationship, your prior conduct, is such that a situation has developed that if you try to contact me at all in any way, it's going to cause substantial emotional distress.
And in order to have some idea of when that is, normally you go to the civil harassment protection order to protect yourself against unwanted contact that is not criminal. It's not leaving a dead rat on your driveway. It's not. It's contact that you don't want that causes you upsetness. And the distinction I'm trying to make is that the civil harassment statute doesn't have that reasonable person requirement. It's supposed to be much broader.
Correct.
But if the reasonable person requirement is satisfied any time the victim's distress was reasonable, then basically every situation that warrants a civil harassment protection order would also constitute criminal harassment. And you're not supposed to interpret the statutes that way, that drains the language in them of meaning.
No, I don't understand that. They have different elements.
I mean, it's supposed to be...
I mean, don't we have to take criminal harassment on its elements? And I'm not sure which element you're attacking. I think you're attacking the sort of reasonable, was the fear reasonable in light of all the circumstances, which is the last element. Are you also attacking whether there were sufficient acts, the three acts requirement?
Well, certainly if we go back to the Lehan case, then the staring at the victim at the gym constantly over a period of years was treated as one incident. And I would argue that makes more sense, because viewing it as one incident, it doesn't matter who that person is.
Because that's all that was needed in Lehan to get to 3. Lehan is written this way. 1, he did something to her car. 2, he grabbed her arm. And then all we needed was one more. Lehan doesn't say, oh, any one of those wouldn't be enough. It says, certainly collectively they are enough.
They named more than 3 incidents that would qualify, but that panel did break out the repeated asking the victim out as something that, while might be annoying, might be bothersome, might be upsetting, is not criminal without having been told to stay away from this person.
Look, I'm going to just look at this more broadly. You had a great brief. You have a good point. What you're saying is that, you know, if you're talking in the abstract, 6 phone calls, only no real contact, no direct contact, 3 phone calls on the other hand, you know, if you look at it in that abstract, then the perils that you are pointing to is a legitimate argument. All right, I'm not going to say what I think about it, but I'll just say it's legitimate. But that is not, that ignores all the context of this case. And how can, at a revocation and probation proceeding, the judge ignore the context? Now, what the judge did do appropriately was say, hey, forget the no contact condition. These 2 people weren't on that list. And so that's not a good basis that's not a basis, period, for me to revoke the conditions of probation. But with respect to this new offense, why can't the judge look at that entire context without running afoul of the elements of the offense, or basically criminalizing what you're suggesting is, what most people would think would be as innocuous conduct? Isn't the context key here?
Well, you can look at the context for all of the other elements. The reasonable person element is supposed to add this element of objectivity that doesn't appear in the rest. Their entire history is certainly relevant for whether it seriously upset them. It did. Nobody's arguing that. It's not relevant for judging the act. You're supposed to be judging the act. And here we go back to.
But you judge the act in the context of these 4 elements. Actually, there's actually 5 elements. And when you're doing that, it involves an examination of context.
Well, so if Judge, I'm sorry, but if that understanding of context was correct, then the case in Commonwealth v. Breca would probably have come out, it would have come out the other way. It talks about essentially the same situation here, where the victim in that case, she described the defendant yelling out of his window at her on multiple occasions, and then she also described him filing a whole bunch of governmental complaints about her, his neighbor, to governmental authorities.
Yeah.
And the reason that they found that the yelling out the window didn't count as an incident of harassment was because she wasn't upset about it until she found out who it was. And that's the exact same thing that happened here, where the parents looked up the phone number that called and told their daughters who called, and that's what upset them, was those and they said in Breca, they said she was really upset by the past incidents, the filing governmental complaints, which weren't themselves incidents of harassment.
No, because in the Bracha case, the person initially was a perfect stranger. There was no history at all. And then when the victim, the alleged victim in that case, then, because the case was reversed, found out who it was, then she became alarmed.
Well, so there
in
was
this
past
case,
history. She
this
just
is,
had to
but this,
find out about
I don't see how this case is parallel, because as soon as, there's a prior history with this, with your client. That's just all there is to it.
Well, there was a history with Breca to the filing of all of these complaints, which is why she became upset when she found out who this person was.
Well, they weren't against her.
They were against her.
Well, not in her personal capacity, right?
I'm not certain. Some of them were neighborhood complaints, but in any case, it shouldn't matter that much. The point is that the court there didn't look back at the past history between the parties and say, oh, well, this is bad enough that anything he happens to do that.
But you know what? Here's something else, and I'm falling into the same trap right now. We're talking about this case as if we're talking about evidence that's sufficient, beyond a reasonable doubt, a sufficiency argument for the crime of harassment, criminal harassment. And we're not at that level. We're just at the level of whether or not the evidence establishes by a preponderance of the evidence. All of your arguments are well taken, and maybe, this case going before a jury would not prevail. Who knows? But that's not the question here, right?
It's preponderance of the evidence, but the question, it really depends on how you frame the question, because if the question is to a preponderance of the evidence, is a missed call, would a missed call cause a reasonable person to suffer substantial emotional distress? A missed call from an unknown number, mind you. And the answer to that is no by any standard of the evidence. The only way you get to even a preponderance of the evidence standard to any standard of the evidence at all.
You're just saying, and there's just no way. This conduct cannot establish, cannot.
Not on its own establish criminal harassment. There has to
And
be
let me
something
ask you
else.
another question, because now I forgot that I wanted to ask you initially. Apparently this case was presented to a grand jury because we had the grand jury transcripts as exhibits. I didn't see anything in the record that tells us what happened to the case after that.
Oh, he was charged, I believe. I don't think it has resolved.
Excuse me?
He was charged. I don't think it was.
I know he was charged by a complaint, because that's in the actual reconstruction.
Oh, was
and
he
then I
indicted?
can assume it went before a grand jury because we have the grand jury transcript. But I don't see an indictment in the record. Did I miss anything?
I didn't see an indictment in the record either. I'm afraid you'd have to ask the Commonwealth. I don't know whether.
All right. So you don't know what happened with that case.
As far as I know, it had not resolved by the time I was writing.
I'm sorry, I didn't quite catch that.
It had not resolved by the time I was writing my brief.
Okay. Well, fine. I'll ask the Commonwealth.
Counsel, you had argued that the problem is that the defendant could not have fair notice that his conduct would be criminal.
Correct. This is the problem essentially with interpreting the statute this way, is that going forward, nobody's going to, if I call my ex-boyfriend on 3 different occasions because I'm trying to get in touch with him, I won't know whether, until I'm charged, that he considers that to be harassment, any contact with me whatsoever.
But in this case, there was no sort of defense that there was some legitimate reason for placing calls to these individuals.
Should you need a legitimate reason to place a call to somebody that you haven't been told to stay away from?
I'm asking you, there was no defense or legitimate reason, any purpose in placing these calls to these individuals.
They interviewed him, but I don't think he gave a clear answer as to why.
They didn't get an answer as to why, at least in the snippet of the transcript that I read. Can I ask you, do we have the no contact order in the record? I couldn't find that either.
Oh, the no contact order that for probation, or for the one that
the original no contact order. Who was on the list?
Yes, it's just victims and families of and family of victims. It's essentially that's the problem. If the probation
No, but I mean it's a list of names, right?
It's not a list of names. It's victims and families of victims. That was why
That's
this
what
was
it
an
says.
issue. It should have been.
But why aren't
a
these
list of names.
people included as victims?
That they weren't victims of the crime that he was on probation for. They weren't families of the victims the crimes he was on probation for. They were victims of other behavior that
the word
some cases
victim was
uncharged.
defined in the no contact order? Was the word victim defined in the no contact order?
No, which is by the judge interpreted as the victims of the crimes that he was on probation for.
But just to clarify, I don't think there's a dispute that these 2 people, the case was no prost against one of them, and then I can't remember what happened with the other one, but...
wasn't charged, I believe.
Right, okay. So maybe with some hindsight, that was an error, but an error that we can't do anything about at this point.
Right. So ultimately the problem with this interpretation is that making it a felony to call people who don't want to hear from you and not being able to find out that these are people that you are not allowed to speak to, it is a felony. You can go 2.5 years in prison if someone believes that you called them maliciously. That's not something that you have any prior warning of. It's going to have a huge chilling effect on First Amendment rights.
Well, I mean, you'd be on fair notice that if you had, assaulted or stalked or done something like that to someone who's not a relative, you otherwise didn't know them, you shouldn't be calling them 20 years after you get out of jail.
I mean, as a blanket rule, if that's going to be illegal, somebody should tell you about that beforehand.
Well, we have this thing, it's called criminal harassment, so we're trying to figure out what that means. I'm sorry, I had another question, but I can't remember what it was. I think we're done. I'm done.
You think you're done? You're all set? Okay. So if the panel has no further questions, we took you over your time. Thank you for answering all of our questions.
Thank you.
Good morning. May it please the court. I'm Dylan Punch, student practitioner under SJC Rule 303 and 3L at Northeastern University under the supervision of Assistant District Attorney Chi-Chi Lee on behalf of Middlesex County for the Commonwealth. And there are 2 issues before the court in this case. The first is whether the defendant was properly on notice that his conduct could result in the revocation of his probation. And the second is whether the hearing judge, Justice Salinger, abused his discretion in finding that the defendant more likely than not violated the terms of his probation by committing 2 new counts of criminal harassment. And just to start, the update on the case is the defendant moved to have the criminal harassment charges dismissed in June of last year, and that motion was denied. That's the latest update that we have. The indictment was not in the record, though.
Okay. So that would be that's public record, so the case is pending.
Correct, Your Honor. So as to the notice issue, first off, the defendant was certainly aware that any criminal violations could result in a revocation of his probation. It was the first condition of his probation contract. And as to the criminal harassment statute, it's not vague on its face, and it certainly wasn't vague as applied here, Your Honor. Specifically, the defendant was aware that these victims had absolutely no interest in having contact with him. They've been reporting him to the police for his contact and attempts to...
Right, but to emphasize Justice Englander's point, these names were not specifically mentioned, and there was no addendum, so to speak, that I saw either in the record that indicated these two women, these 2 victims, or their families, were part of the case.
That's correct, Your Honor. As far as the no contact provision, as was mentioned, is the Commonwealth null pros the charges involving one of the victims, and it was ambiguous as to whether or not it applied to the other one, which is why the no contact provision was found not to have been violated.
So, query, again, following up on Justice Englander's point, if there was no list, how is the defendant supposed to know who was on or who was not on it? Or even how does the Commonwealth know for that matter?
Well, Your Honor, the issue's not so much that he was prohibited per the no contact order. It was just the fact that these were two new counts of criminal harassment. I mean, he was on notice that these.
So you're saying it's a bit of a red herring, that whole issue?
Yeah,
is that your point?
Yes, Your Honor. The whole issue is that this was two new counts of criminal harassment, which was violating the first condition of his probation.
He'd only made one phone call to each. You don't have a case.
We would not have a case, Your Honor, but he made
two phone calls, not a case.
No case, Your Honor. But here we have 3 phone calls to one and 6 phone calls to another. And as I said, these victims have been reporting the defendant to the police since the 90s. Of course, the defendant's aware of the history he has with the victims. And furthermore, the defendant has been investigated and criminally charged for various harassment complaints over the last several decades. So certainly he should have been aware that this would be prescribed by the criminal harassment statute. Now, as to the abuse of discretion argument, here, the record contained sufficient reliable evidence that justified Justice Salinger's findings that the defendant more likely than not violated the terms of his probation by committing these 2 new counts of criminal harassment. And the record places these phone calls into the necessary context, which Justice Salinger appropriately considered, and which is the decades of harassment, the history of sending these victims harassing letters and placing phone calls, showing up to their homes in the 90s and slashing the tires of all the vehicles belonging to their families. What Justice Salinger really found troubling is that he was incarcerated for 23 years and, quote, immediately started a harassment campaign against prior targets once again. And this convinced Justice Salinger that it continues to be necessary to incapacitate the defendant in this case.
Was there, I should have asked your opponent this, but was there a First Amendment argument that was made in response to the probation revocation case?
There's no, as far as I'm aware, there's no First Amendment argument being made here, and the underlying issue isn't the content of speech, it was actually his conduct of placing these phone calls, Your Honor. And furthermore, with the recent Counterman decision, the recklessness standard was certainly met, as the record reflects. And it's, so in short, no, Your Honor, there's no First Amendment issue here.
This is conduct, not speech.
This is conduct, not speech. It was the actual physical act of placing these calls to the homes of the childhood homes of these victims, Your Honor.
I understand the argument. I think it's the right argument to make. I think it's a interesting line to try to draw sometimes.
Yes,
right?
Absolutely, Your Honor.
Because the argument that's being made by you guys is that the conduct is criminal because it was conveying a thought.
Well, Your Honor, and that being the case, the thought was certainly a reckless disregard for the harm that it was going to cause, and did in fact cause to these victims. So the recklessness standard, even if it was a speech issue, it would still, there would still be no First Amendment issue in this case.
Okay.
Now, importantly, the criminal harassment statute is designed to protect victims from harassment before it escalates into something more dangerous. And as the record reflects, Justice Salinger considered this, and it's very reasonable for him to infer that the defendant is likely to escalate his conduct again, as he did back in the 90s. If there are no further questions?
I don't have any. Nope. No further
Commonwealth
questions.
rests on its brief.
Nice job, counsel. Both sides.
Yes, yes. It's a case that involves an interesting issue, and we thank both of you for your bringing your arguments to our attention. Thank you. Brief recess? All right. The court will be in recess for about 15 minutes. Thank you.
All rise.
recused. We're back in recess. Thank you. So if I'm correct, the next case on our list is the Department of Children and Families versus Mother, 2022-1000.
Good morning. If I could just first get the clock set to 15.
Excuse me?
My clock was at 7.5, not 15.
Okay, there you go.
It's been corrected.
All right.
Good morning. My name is Alan Campbell. It's my privilege to represent Mother in this case. I've raised 4 issues in the brief. I'm fairly confident we will not get to all of them. I'd like to start with the first issue in my brief, and that's that numerous findings which are critical to the ultimate finding of unfitness are clearly erroneous. This actually also relates to the second issue, that the findings don't support the ultimate determination of unfitness. So there are 3 broad categories the judge found that led to the unfitness. That was untreated mental health, or allegedly untreated mental health, alcohol and anger, and housing. Many of the findings which I've challenged go directly to those 3 critical issues. As to the mental health, we have supplemental findings 9, 10, and 55, which all say some variation of that Mother couldn't even watch the testimony of the foster mother, or couldn't accept things that she didn't agree with. And the court says that Mother turned her video off several times during the case. There's one instance on the record where Mother said she needed a break. It was a brief break. She was granted that. There was at least one time when Mother didn't have her camera on. But contrary to the judge's finding, turning your camera off doesn't stop you from seeing or hearing what the other witnesses are doing. It prevents them from seeing you. So the finding just simply isn't supported. Even if Mother was turning her video off several times during the hearing, that doesn't mean that she was unable to hear what was going on. And again, and those relate to one of the 3 pillars of the decision.
They relate to one of the 3 pillars, if you want to accept your characterization that there are 3 pillars.
Well, that's the.
But no, let me finish. But how critical do you think this was as compared to a series of other findings that the judge made? I mean, I will say, I think you did an excellent job in your brief of presenting your client's case, but you deconstruct the findings in order to do it. And I, having read the whole thing, it did not strike me that the fact that Mother had turned off her, if in fact she did, her Zoom camera was critical to what the judge was expressing through that point, which is that the Mother showed over a lengthy period of time that she would not confront the reality of what was going on with her children.
Well, that finding in and of itself is certainly not critical. If that was the only finding that was clearly erroneous, I wouldn't be making this argument. But there are, I believe it's 15 findings of fact that I've argued are clearly erroneous. The combined effect of all of those shows that the judge did not pay careful attention to the evidence. And as to the beginning of your question, I didn't come up with these 3 pillars. The judge, and I don't have the exact spot, but I believe it's at the beginning of the conclusions of law, or the beginning of the summary says, these are the 3 issues that are the primary thing. So it's the judge's own words.
Well, I think alcohol abuse and anger, maybe more anger than alcohol abuse, and mental health, I get those. I'm not so sure that housing was critical to the judge. He does mention it. I'm not sure how critical it was. That's why I was questioning.
Well, the judge says the primary barriers to reunification were, and then he lists those 3 things, including housing. And housing is mentioned several times in the conclusion, in the conclusions of law when he's describing his rationale. And again, to find that somebody doesn't have stable housing when they've lived at the same address for 2 years and there was no eviction order or any proceedings, they were intended to be there for at least another 5 or 6 months. The judge didn't pay clear attention to the record.
Well, there was also evidence that there was no lease, that the apartment was owned by her boyfriend's parents, of which there was a volatile relationship, correct? I mean, it wasn't, I don't know how you can say it's clearly erroneous. There's different conclusions that can be drawn from those facts.
Well, the term unstable housing means something. It doesn't mean that at some point you may lose your housing in the future. Everybody at some point may lose their housing in the future. It has to mean that you're changing houses or that you're in, early on in the case, she did have unstable housing.
Mm-hmm.
She moved several times. But to live in a place, and you don't need a written lease to live someplace.
I suppose that would be true if we didn't have lengthy explanation of how the judge got there. I mean, hadn't there been an event shortly before trial where the parents had been chasing your client down the street and your client had to pull out a taser?
There was.
And wasn't that in evidence at trial?
There was some incident with that. But again, despite the volatile relationship with her boyfriend, which had permeated the case, if you, I would suggest that it wasn't as volatile as it seemed, but even if you accept the DCF's premise that it was a volatile relationship, she had been in this house for the entire time. It was over 2 years at the time of trial. It just simply wasn't unstable.
Well, instability can mean other things rather than they've been in the same place, but that the circumstances of the housing are not within her control, right?
But that's true for essentially everybody.
No, if you've got a lease, and that's why
You
there
own
was,
a home?
I suspect, some focus on the lease. If you've got a lease, you have some rights to stay there. You're paying your rent, you have some rights to stay there. But if you're living there under circumstances where somebody's just charitably allowing you to live there and it's dependent on the relationship
But
between her and this boyfriend.
without a written lease, having lived there and paid some rent, she had a tenancy at will. They could say to her, leave, but she'd need to be evicted. It was her place for 2 years. They would have had to go to housing court. Even if she had a lease, anybody could lose a job. And if you can't pay your rent, then you can be evicted. So that was the same situation for her. They could have at some point decided they didn't want her to live here, and then they would have given her notice. And she was actually on a waiting list for other housing. And DCF offered her, even though they said they didn't like the housing, they offered her no assistance whatsoever in obtaining housing. They didn't even hand her a pamphlet and say, this is what you could do to obtain housing. And there is actually a related issue that is worth mentioning.
What else do you think you want to focus on as to the clear error that the judge committed? Let's leave
Are you
housing
asking
for a moment.
specifically clear error of findings or of the big picture?
Housing is one issue. What else do you want us to focus on where you think the judge committed clear error?
There are several findings of fact, primarily finding 14 and finding 10, where the court cites to a 51A and concludes that mother was neglecting the children. 51A is introduced to set the stage. The finding of neglect is a substantive finding which will impact the case. And if the judge is finding early on, mother neglected the case here, it adds to the whole decision and it's part of the continuum of the decision. It's black letter law.
Aren't there circumstances where, I take that point, but wasn't there other evidence, at least with respect to some of the things that the judge credited, from which the judge could have found neglect where there was actual evidence in the record? Let's take the instance that led to the children being removed, the children hanging out of the window.
That actually isn't one of the specific findings. Well, the children weren't hanging out of a window. They were in some way leaning out of a window. Even the DCF social worker testified that she thought that incident was overblown. And the DCF didn't say, we removed the children because they were at imminent risk of death. They said it was the condition of the housing and that she had taken prescribed Vicodin without having a proper caretaker. So I don't actually, even though the hanging out of the window initiated the removal, I don't think that was actually why they were removed.
Okay.
So there were actually, and then there's others, finding 2 and finding 16. The court is, again, looking at 51As and Bs, which are supposedly the only primary fact, and agreeing with and endorsing findings by DCF that mother had abused, or neglected rather, the children. And in one of them, that mother was not engaging in services. Again, evidence was admitted for a purpose, and the court is using it for a different purpose, to mother's detriment.
Is it okay for the court to rely on the conclusions in a foster care review? And say I adopt those?
That is an interesting question that I don't believe I have specifically addressed in my brief.
No, you haven't. But I found myself going through this and bracketing the instances in which the judge made that comment, that DCF, or that this conclusion was reached and is apparent in the document, the court adopts that finding. And I realized that court used that for statements that were made in 51As or 51Bs, and also a foster care review, and I think there was another document as well that was not a 51A or 51B where the judge did that. So I was wondering.
It perhaps would have been problematic. Since I didn't challenge that specifically, I don't know what to say about that. I certainly, I don't think that undercuts my other argument if the court is allowed to. And I actually would like to note that one of
Court
the...
investigator. What about the court investigator's report? Do those conclusions come in as substantive evidence? Assume they do.
Typically, the conclusions and recommendations are struck. I don't know specifically if that happened in this case.
Okay.
And then another finding, again, showing inattention to the evidence, the court found that mother never took medication. The testimony was that she had started taking medication, I believe it was 6 months prior to trial, and DCF, the social worker, confirmed that. So another instance of the judge just not paying attention to the evidence. And then there is an interesting one that what the judge theoretically saw on the Zoom video was used for a finding that the housing was unsafe.
And you liken this to a view in a case?
Well, it's something that I've not seen in any cases and not come across in 25 years of doing cases like this. And that was the only analog that I could think of, is that, you know, sometime in a criminal case, you see it, the jurors will go to an apartment building where a crime allegedly happened.
There are cases that says, I assume that there are cases out there where a land court judge has gone somewhere and said, on the view, as part of his opinion, on the view, I observed the following. And is there a case that says, that's no good, it's not evidence?
There are certainly cases in the criminal context that says what the jurors see during a view is not evidence. It's only there to allow the jurors to understand the evidence that is presented.
Justice Englander is bringing up a different point, which is sometimes the view is part of the evidence. In other words, in a criminal case, it's different, and the standards are different. But what if there had been photographs of the apartment, for example, instead of actually seeing the person?
Well, had photographs been introduced into evidence, those photographs would have been part of the evidence, and Your Honors would be able to look at them.
My skepticism is that I think for a long time land court judges have been going out on views, and I don't think I've seen a case where someone has said, oh, you cannot rely on what you saw and what you reference as part of the evidence of the case. Doesn't make sense to me. I understand the problem that it's very hard to record it.
Well, it's also, a land court case is very different than a care and protection case, or even different than a criminal
Not
case.
in this context. He's basically saying, I saw what was important for me to make a conclusion, which is I saw the state of the home, and that state of the home was X. Wouldn't be any different than I saw where the tree was.
Well, it would be, Your Honor, because the parties weren't on notice that the judge was going to be asking one of the parties to give a tour of the house. And the judge didn't, on the record at the time, say, while anybody could have challenged it, say, I'm seeing X, Y, or Z, which would have then allowed, counsel to, depending on the way, well, it was the mother, so it would allow mother's counsel to either, she had been called, so it would have been cross-examination.
Did I read in one of the opposing briefs that mother herself had showed things in the apartment on Zoom, and
Right.
had also invited the judge to look at certain things in the apartment?
I believe that was during the judge's extensive questioning, which spans pages and pages. I don't think she said...
The judge says in the judge's findings, he says, mother was proud to show me decorations in the house.
That was when the judge had asked her to show things. In response, she was proud to do it, but that doesn't, even though she may have been proud to show it, it doesn't mean that it was still improper for the judge to have done it when there wasn't going to be some indication that this was happening.
So it's, okay, so maybe some issue with notice, with her having an understanding that that's what the judge was doing. But you liken the situation to a view, isn't it? Could it also be analogized to judges making observations of the person themselves when they're in the courtroom? So that's not specifically evidence in the case, but the judge can say, I saw this person seemed intoxicated right in front of me in the courtroom. Not mentioning it, right, during the course of the proceedings, but that's, judges' observations can be noted.
The judge could certainly make observations, but what the problem is here is the judges then made findings of fact, which I argue were essential, combining them all were essential to the ultimate finding of unfitness, and that was the problem. The judge was certainly free to see the room, to understand the testimony of this is what the apartment looked like, okay, that's where the railing was, et cetera. And if I could just have one more brief point.
Actually, your time is up.
Rest on my brief for the additional fact.
I see no further questions from the panel, but thank you very much, and thank you for answering all of our questions.
Thank you.
Okay, and now, with respect to the appellee attorneys, you're going to split your time 7.5 minutes each. Is that correct?
That's correct, Your Honor.
All right. So would you like me to give you a warning at minute number 6 or
If
so?
you could just let me know when I have a minute to go.
I'll be happy to do so.
Can you all hear me okay?
Yes.
Okay. Thank you, William Cuttle, for the Department of Children and Families. The department's asking this court to affirm the trial court's decree terminating mother's parental rights. As the court set out in her findings and as the department sets out in its brief, it was overwhelming evidence, sadly, of mother's ongoing mental health and alcohol issues, her erratic and dangerous behavior that was consistent from 2016 up until the beginning of trial in 2021, and importantly, her unsafe and unstable housing, which did in the earlier on when the children were in her care, and what the court was concerned about if they were ever returned to her care, would put them in harm's way, given the problems with the staircase and whatnot that the folks were just talking about a couple of minutes ago.
But DCF didn't think that the issues with the house were...
The social worker did not, Your Honor. But as we say in our brief, the court didn't have to rely on what the social worker said in that particular case. There were, as we set out in our brief, there were incidents involving mother and the father of these two children from 2016 to 2019, involving violence, instability, and these issues unfortunately carried on through mother's life. We tried to provide her with services. She did do some services. She participated in a parenting class. She initially wasn't able to complete an anger management class, but I think she started to do one later on in the life of the case. She participated in a parenting evaluation. Her own expert testified before the court. Significantly, her expert was not able to recommend that the children be returned to her care at the time because, in the expert's opinion, mother had not come to the place where she needed to start working on her issues. She had just begun to identify her problematic issues, and I think that's a significant finding that the court made. The concerns that mother has, that they were just talking about the 15 erroneous findings, as we say in our brief, many of those findings are not erroneous. They're disagreements with the weight of the evidence. We do concede that I think it's supplemental finding 20 was erroneous in a part of summary finding 6, because both of those concerned the children's medical needs at the beginning of the case. The judge erroneously found that their medical needs were not being met at the time. There was but she cleared that up later on, as I say in our brief. The challenges to the findings are frankly not really concerning overall to the judge in this case. The judge did a very thoughtful job reviewing all the evidence. Clearly, these children needed to be taken out of the home. Clearly, mother was given chances to work on her issues, and she wasn't able to do it, unfortunately.
Do you agree with your opponent that there are several findings where the judge adopts conclusions of a 51A or a 51B and that was wrong?
Well, I don't think it was wrong, Your Honor. As we say in our brief, well, first of all, as I know you're aware, Your Honor, 51As are the information in those documents are used to set the stage. 51B information for primary facts, observations made by the workers, statements made by parents, that's admissible evidence that was in the record for the court to review.
Sure, but the judge is not taking the conclusions as evidence, but and on several occasions the judge says DCF supported the allegation that mother was neglecting the children. The court adopts this conclusion. That's finding 14. That's wrong, isn't it?
I would not agree that it's wrong. I haven't seen that done in a lot of cases, Your Honor, but I would say, as we said in our brief, it's very reasonable that the judge reviewed all the facts contained as she was writing that particular finding and came to the same conclusion that the department investigated.
Well, the sentence, DCF supported the allegation that mother was neglecting the children, shouldn't be in here because a 51A or 51B is not in for that purpose. That's not evidence, right? The conclusion of DCF is not evidence.
Not unless it's not objected to, Your Honor. That's correct.
And it was here, and the judge said, I'm just taking it to set the stage.
I don't know if any of that was objected to at trial, Your Honor, and that's what would have to be originally objected to. I don't know if there were motions in limine in this case. I do not remember. I know that the judge made, at the beginning of the case, she said how she was going to treat 51A reports and 51B reports. I'm aware of that. But I don't want to get caught up in this issue. My position on it, Your Honor, the department's position is that there was no error, and quite frankly, even if I take the position that you're suggesting, it wouldn't make a difference in this case. The conclusion of neglect was that the court made is based not just on those particular findings, but on the entire record. And it's not even, it's overwhelming the evidence.
I just want to interrupt you, excuse me, let you know you have about a minute and 20 seconds left.
Thank you.
And I also want to interrupt you to say, if I may, that would you like to address the adequacy of the adoption plan, another issue that was raised but we didn't actually get to with respect today?
Certainly, I'll do that quickly. So the department's position is that the adoption plan, there wasn't a written plan, as there are in some cases, but you don't need to have a written plan. The court had...
No, but there was almost no information here other than the fact that the plan is for adoption. The judge herself, in fact, questioned the adoption social worker adoption specialist.
I believe there were 5 pages of testimony, as you're suggesting, that we refer to in the brief. But that information was significant because the court was able, in that information, the worker provided the court with the information that the department's looking for a single or a couple to take care of both of these children, not one of them, to find a family that could deal with their educational and emotional needs, which were being addressed by the foster family, and the department was very aware of it. And significantly, the judge had enough information to make the finding that post-adoption visitation was in the children's best interests.
To be fair, the judge pretty much prompted the social worker with respect to some of that information. Your time is now up, and I understand the department's position on that. I'll just see if the panel has any further questions for you before you. And no. I see no further questions, so thank you for your argument. Okay.
Good afternoon, Your Honors. May it please the Court. My name is Joan Altimore, and I do represent the 2 children in this matter. This case involves a mother who has not, at least at the time of trial, developed the skills necessary to handle the basic needs of her 2 children. Mother continuously failed to avoid or alleviate the problems and the difficult situations, as well as failing to attain the parenting skills necessary to parent her children.
Well, is it true that there were gains made towards the closer to trial than had them made beforehand?
I'm sorry,
closer to the time of trial, excuse me.
I thought post-trial.
Yeah, excuse me.
Gains had been made prior to the time of trial. However, there's 2 points. One is that those gains were made if we look specifically at her alcohol abuse. One of the tasks on her action plan was to obtain an evaluation, for which finally I believe it was in early 2020 or late 2019, Mother's Counsel did retain a parenting evaluator, or excuse me, an evaluator, who produced a report. Part of the problem is that all of the, how the report was prepared was evidence presented by Mother, her admissions to her evaluator, and she did not admit to certain facts, one of which was of significance, which was her alcohol abuse. She did not tell the evaluator at that time that she had been actually hospitalized twice for acute alcohol intoxication. A second evaluation was conducted in 2020 by the same evaluator, who then changed her diagnosis for Mother, adding in alcohol abuse. That same evaluator then testified, as said by my brother counsel, that same evaluator testified at the time of trial and stated that she did not recommend reunification between Mother and the children because Mother had not done the appropriate work. There was a point in time where the department was endorsing, told Mother that they were going to work towards a reunification plan. Within a month of that, they had also filed a notice of termination of parental rights. It is common, in fact, it is quite frequent in most cases, that you work on concurrent planning in these types of cases. And so one goal can be for Mother to work towards reunification while at the same time searching out an appropriate post-termination position for the children. And I would like to point out it's...
So at the same time, is it possible that at the same time that the department is working towards unification, there would be an effort, for example, to find an adoptive family for these 2 children?
That is completely true, Your Honor. These 2 children...
Just a tad inconsistent.
No, Your Honor, because you're recognizing that the parent can still make improvements, but they're not necessarily at that point in time. So you want to give them the incentive, frankly, to continue to do the good work that they're doing, because in general, in a life sense, that they should be doing this work anyway to improve themselves. And then there would be an improvement, hopefully, in their parenting skills.
Here I asked the question about the recent gains, mostly because when you have basically no adoption plan, but we're putting them up for adoption, there really was no plan to go to 1 parent, 2 parents. So of course you're going to go to a 1 parent or a 2 parent family. And no one's looking for a 5 parent family. So that wasn't, or siblings or something like that. So that was really saying nothing. And to find somebody who could care to keep the children together, that seems to me pretty basic, that you would keep the children together. But so with no real plan and with the gains being made by Mother, there's got to be a confluence there someplace.
But there's 2 parts to that, Your Honor. One is, the argument is that Mother was actually not making the necessary gains. Throughout the course of the open care and protection, there were approximately 12 police responses between Mother and the police. Most recently, there were 3 police responses in May of 2021.
Trials in June, right?
So that's not so much an improvement. In fact, actually, it's an increase. I will point out, Your Honor, that it's post-trial knowledge, but the children have been placed in a pre-adoptive home at this point in time. But quite commonly, you do have a situation where the children are placed in a foster care placement. First, you always look at kin. Kin had unfortunately been ruled out in this situation. They were in one foster home It was very good, but they had to transfer to another one. At each of those times, you're looking to see, is that foster home the possibility of a long-term placement, or is it not? And then what we don't necessarily factor in for this particular case is why did they leave that original foster home? And it could be a circumstance completely separate and apart from the reason, from the children. But they were always, the department is going to always be looking for stability for these children. And can you, unfortunately, and this is everywhere in the country, do you have enough people opening up their homes to either foster children or pre-adoptive children? And so you're always looking, but are you always able to find? As a practitioner, I'm always arguing you should never go to trial without a child. This is my argument. You should never go to trial, and especially representing children, when there's no pre-adoptive identified home, because you don't want to create the legal orphan of the child. But that position is separate and apart from, is this parent ready to parent her child? And I think it's quite clear from the record, her choices, starting from 2016, when her involvement with DCF as an adult and as a parent started. And the care and protection did not open until 2019. So a lot of work had continuously been done with this mother. The father was not involved. The choices she made after the removal of her children, she was 23 years of age at that point in time. The boyfriend she picked was a 16-year-old. The 16-year-old who the department had to put one of her tasks to be, do not provide alcohol to your underage boyfriend. I would also point out, there may be, my brother counsel points out, there are 15 contested findings, but there's 57 findings in total. So what he is contesting is not even a third of what the judge actually relied upon.
Can you help me with something? And this is just my ignorance, but so there's an argument that says this was a bare bones adoption plan and it wasn't good enough. And I'm like, well, what else would you usually see in the plan besides we're choosing to place this child for adoption, which means they've ruled out Kim. So that's one, that's a key decision. Kim is ruled out. We're going to put the child with put the two children together. Okay, they can be together. What else would you usually see?
Your Honor, my time is up, but if I just may answer that particular question. It's an excellent question, because what the department is striving for, and frankly, I'm not always supporting the department, because as counsel, we do represent mother and father, so don't take this as the position in terms of stating that they have a problem, that they have to go out and solicit. They have to go into your community. You see television ads, you see newspaper advertisements.
Because your time's up, I'm going to cut you off and just say, what else would you usually see in a plan besides what we have here?
Basically, Your Honor, what you would see is that they are soliciting, they're actively looking, they're trying to match a family. They have yet to find a family, but that doesn't stop the reality of that. Can this parent parent this child at this time?
Well, thank you all very much for your arguments. We'll take the case under advisement. We know these cases are difficult, and we'll do our best to get an answer as soon as we can. So thank you very much.
Thank you, Your Honor.
We're now going to come to our last case on the list today, which is Derbyshire Real Estate Trust versus Karen Perlin, and others, 2022-0914.
Good afternoon, Your Honors. My name is Stephen Kuzma. I represent the appellants in this case, and it's been 37 years since I've been before the appeals court, and I hope I can only do as well as that law student earlier this morning. Time will tell in about 16 minutes. Your Honors, this is a classic case of undue influence and breach of fiduciary duty against the patriarch of the Derbyshire family. We'll call him Senior. This case involves Senior, his daughter Karen Pellerin, and Junior, his son, who worked alongside him digging clams for over 50 years on the South Shore. As close as a father and son relationship as you can get, something all of us would desire if you're a father. It's a classic case of a breach of fiduciary duty by Karen Pellerin in the transfer of the 06, transfer of the property from Senior to herself in the real estate trust.
Let me just ask you, I appreciate your description as this being a classic case of a breach of fiduciary duty, but the judge found otherwise.
Judge found what?
The judge found otherwise.
I understand that, Judge, and there are a number of findings.
After years and years and years of this family litigating this case that got their day in court and everybody testified, and the judge made some credibility findings. So can you point us more directly to where you think that the judge is incorrect and why?
There's a number of findings that were incorrect on its face, Judge, on its face. Number one, the court believed that there's could be no explanation other than Senior was the settlor, the trustee, and the beneficiary of this trust. That is not found in the evidence. That's pure speculation on the judge's part.
Well, wait a second. Let's just stop. Because it seems to me, as you're going to find as you hear my questions, that this is the most important issue in your case. The judge found that you did not prove that your clients were the beneficiary of the nominee trust. You're saying that was clear error?
I am saying that was clear error.
And on the basis of what evidence is that clear error?
Number one, there was no evidence to support that finding. It was pure speculation. In the transcripts, if you read the deposition...
Wait, whoa.
You're reversing it.
Yeah. It's your burden of proof. You have to show your clients were beneficiaries of the trust. The judge found you did not carry your burden. So when you say there's no evidence to support it, what evidence did you put in from which we could conclude that it was clear error for the judge to conclude you didn't prove your case?
Number one, Senior told Junior that the children were the beneficiaries of the trust. Number two, Senior showed...
Someone put in evidence. Junior put in evidence.
Correct.
My dad told me the children. The children?
The children. That would be himself, his sister...
Including the one who had been deceased at the time that it was written?
Yes, Your Honor, and that was drafted by Attorney Wax in 1993. So that may have been a mistake on Attorney Wax's part, but not attributable to Junior or Senior. Number two, Junior testified that the schedule of beneficiaries was shown to him by his father. Number three, Attorney Wax testified at his deposition very clearly that the children were the beneficiaries, and this is what he always does. The trust itself refers to beneficiaries. It doesn't say Senior shall be a beneficiary. It's beneficiaries. That's what the trust document itself says. That document was shown to Junior, and there was no cross-examination of Junior on that point. So my position is that the judge made a quantum leap in her rationale that all of this is to be not believed, including Attorney Wax's statement. Attorney Wax testified at his deposition, before trying to walk it back a little bit, he testified that the children were the beneficiaries. To me, those are 5 or 6 points on our side of the ledger.
His testimony wasn't all that direct, and there was also evidence on the other side. Primary being the fact that none of the beneficiaries were ever consulted when there was transfers of property, including the property to Junior.
Let's
right?
talk about that. Yeah, that's correct, Your Honor.
So now the judge has got conflicting evidence.
I'm sorry?
The judge now has conflicting evidence.
The judge has that evidence, and what the court did is they made a leap from, well, there was no one consulted on the 01 and 02 transfers to junior. Therefore, this must have been Attorney Wax's standard of practice of not consulting with beneficiaries. The judge made a fundamental mistake. Judge Wax was not involved in the 01, 02 transfers to junior, which everyone in the family knew was a result of him working alongside his father and developing this shellfish business on the South Shore. So, and if there was no beneficiaries consulted on the 01 and 02, I would submit this. There was a lot of evidence that everyone in the family knew about the transfer. There's something called acquiescence. If you fail to dispute
Can we
a
just back
transfer
up for a
from
moment?
trust-
Can we back up? You say that Attorney Wax testified that the children were the beneficiaries of the trust.
That's correct, Your Honor.
And that's what he always does?
In most cases, according to Attorney Wax, who I guess drafts a lot of trusts and does real estate, or did, typically a schedule of beneficiaries is always attached, or at least held, when a trust is done. These are the beneficiaries. That document has gone missing. But more importantly is, his testimony was that he did it in this case, the schedule of beneficiaries, and it named the children. If you look at the very wording of the trust itself refers to beneficiaries. How the court can go from beneficiaries plural and that clause in the trust that says you can't do anything unless you consult the
It's not
beneficiary.
difficult to see how the court did what she did. There is no evidence written as to who the beneficiaries are. The only evidence of how the trust is treated, the only evidence objectively, not what an interested party may say, is Merle transferred two things out of the trust, and both of them he did by himself. That's the evidence. I mean, to say how did she get there, it's pretty clear how she got there, right?
Well, I disagree, Judge, because you did it in 01 and 02 doesn't mean that you did it 5 years later when you're infirm with mental and physical disabilities.
But it could. It could mean
that is what he
could.
did.
I
Well,
granted
the point is the judge is the one who makes that finding based on the evidence.
I think it's a quantum leap to go from 01, 02 with a different attorney involved when everyone else knew about the transfer to doing it in secret in November of 06. It's entirely two different things. This wasn't a custom of Attorney Wax or anybody else. This was something that was done completely separate and apart of the way it was done in November of 06. One was above board,
The
which
judge
everyone
could
knew
find,
about.
I'm sorry, there was a commonality to each of those transfers. Both of them were done by Merle.
Both of them were done.
Both of them were done by Merle,
Senior, right.
Senior. And he signed them, right?
Yes.
And the judge could find that's the commonality.
I don't think you
No,
can look. I don't
it's clear
believe-
error for her to think
I'm
that
sorry?
way? It was clear, your argument is it was clear error for her to think that way.
Absolutely. I could understand why she may think that. But it's pure speculation to say that this way equates with this way 5 years later, especially because one was done with the consent, well, with the knowledge of all of the beneficiaries, Judge. They all knew about 01 and 02. The one in November of 06.
Circumstances
was
had changed.
Total secret. It's circumstantial, but it is
No,
evidence, Judge.
circumstances had changed, but she explains her reasoning in great detail, how she saw this. I think she explains it in great detail. She says things had changed, the children were no longer getting along, that was clear, but what she says is, and she finds, that Merle knew what he wanted to do. He wanted to give the second house to Karen.
Well, Judge, that's in opposite to his very handwritten statement. And I've done a lot of these cases in Superior Court, and typically you have to go back and kind of put the puzzle back together years afterwards as to what the donor's intent was, or the elder's intent was. In this case, we have seniors' own handwritten statements that this was to remain a Derbyshire home. That was in 2002. 26 Eldridge shall remain a Derbyshire, and Karen shall change her name, and only a Derbyshire shall live in this home. Somehow from there we get to 06 when the defendants, specifically Karen and Tom and Sarah, call Attorney Wax, another misfinding of the court judge, that Attorney Wax was Senior's longtime client, longtime professional relationship. There was no relationship since 1993 with Attorney Wax. This was somebody who was called by the Pellrins to effectuate this transfer. The court got something from the closing argument of Attorney DeFazio, who said, well, Wax was his longtime client, professional attorney. That's why he was called. No, there's no evidence of that at all in the record, other than a statement in closing by Mr. DeFazio.
Well, did he go to other attorneys in between?
And he did.
No, only Junior did, correct? Merle did not. Was there evidence that Merle was?
Yes, Merle went to an attorney in August of 2006, right before the November transfer. He went to an attorney, again set up by the Pellrins, by the name of Attorney Fitzgerald. Attorney Fitzgerald revoked Junior's power of attorney and did a new power of attorney and healthcare proxy for Senior. That established the fiduciary relationship. When a fiduciary acts to their own benefit, such as this case, there's a presumption and the burden of proof shifts to the other side.
I've got questions about that, and I understand that argument, but there's a predecessor point, okay? I mean, to me, again, the critical point is the judge has found that you didn't establish that the children were beneficiaries. What the consequences of that are is tricky, in my view. But those are more questions for your opponent. But if, in fact, the judge, if we were to conclude that the transfer from Merle to Karen was valid under the trust, do your clients have any standing to object on undue influence or competency grounds?
If you assume that it was valid, no, because you're assuming that there was competency, which there...
No, I'm not assuming it's competency. I'm saying if it's valid under the trust, can you still raise the competency and undue influence arguments? Because the judge found they're not beneficiaries of the trust. And then you got the question, well, was it the trust that transferred the property? Presumably it was, presumably.
Yes, you can, Judge, absolutely.
How can they challenge it then?
Under a tort of intentional interference with inheritance, you can still challenge the undue influence and capacity.
There's no inheritance. The property is gone from the trust. The property was if we were to conclude the property is properly in the trust and was properly transferred from the trust, then there's no inheritance left, is there?
There still is. There still is.
How's that?
It's undue influence and a capacity argument to even assume that we know it was transferred from the trust because Attorney Wax had the documents. This is a matter of record that would put somebody on notice that you have to have the beneficiaries consulted. And I noticed, Judge, I hope I'm responsive, but I have 5 seconds left. I just want to say...
relax, because at least I apologize to my colleagues, but I need to understand this because I think it's pretty darn complicated. And I would think if we were to conclude the transfer from the trust was valid, okay, that the only people who could challenge the transfer would be those who were beneficiaries of the trust, not someone who might take under a will that we never got to because the property's been transferred.
I hope I'm understanding you, Judge. I'm not sure.
Well, your brother raised this in his brief, so I mean, I'm not making it up.
No, so the heirs, as well as the beneficiaries, have the right to maintain an action. They have standing to challenge the method of the transfer under an interference with inheritance, which is supported by 2 wills signed by senior.
But the inheritance, why isn't, so this is the part I don't understand. Okay, I hear what you're saying, but I think you're skipping over something. You're claiming it's an inheritance. I think the property's out of the estate. It's in a trust. But you're saying to me, even if the property's out of the estate and in a trust, the people who would take under the estate still can challenge what the trust did? Why?
Yes, yes, because they are heirs.
That say that?
They are heirs, and this was subject to a motion to dismiss.
Estate, not heirs to the trust. There's
No,
beneficiaries to the trust.
Correct, Your Honor. They're heirs of senior. And they have the absolute
All right,
right.
and so they have the absolute right to take from the estate and argue, you know, that there was the estate was depleted or something like that. But this properties, as Justice Englander is pointing out, were already taken out of the estate and put into a trust. I think that's the whole point of doing that, isn't it? So it's not part of the estate.
It is part of the estate, and the estate can still be opened. An estate can still be opened in this case.
If we concluded that the judge was wrong about the validity of the transfer, then we'd have a question about where the property is.
Correct.
Right?
Yes.
And then maybe it goes back to the estate.
Yes.
But if we conclude that the judge is right, that you didn't prove that your guys were beneficiaries and therefore the transfer is valid, how do you have standing to still raise competency and undue influence? That's my question. I think we've probably gone around on it enough times.
Can I say one?
Yes, sure.
Can I say one thing on 23379G?
Yes, I guess.
Really, 1 minute.
Yeah, go ahead. Yes, go ahead. No, go ahead.
The medical records were not properly admitted into evidence, and I'll tell you why. And the statute has been around a long time. You cannot have a keeper of the records sign on behalf of a doctor and attest on behalf of a doctor to get in medicals under 79G. What happens is a keeper of the records can produce the medical records, but those medical records have to be attested to by the physician. That's not what we have here. We have a doctor.
Okay, we got it.
Thank you very much.
Yeah,
Appreciate
thank you.
it.
May it please the court, my name is Ray Jennings. I represent the appellee, Sarah Pellerin. Judges, I think the judge got it right. I'd ask you to affirm the statements of facts that the appellant is citing in his brief and that is relying on today were not the facts of the case. The facts of the case were what Judge wrote in her 43-page decision. She was free to weigh all of the evidence and credit some of it and discredit other evidence, and that's what she did. That's what fact finders do. The facts the judge found support her legal conclusions.
She found that there wasn't proved that there were any beneficiaries of the trust.
She found that in all likelihood, Merle was also the beneficiary of the trust.
And doesn't the trust fail?
And I'd posit a different example, Judge. What could have been the case is that he was the primary beneficiary of the trust, and there were others named as contingent beneficiaries, and that would explain the phrase in the trust document itself that refers to beneficiaries on the schedule. You would do that if you were planning your estate. You wouldn't just leave yourself as the sole beneficiary. you could leave yourself as a sole beneficiary and have others as contingent beneficiaries, and by doing so...
If that's the case, okay. If that's the case, she didn't make that finding,
She did
by the
not.
way. But if that's the case, don't all the contingent beneficiaries have to be consulted before the property is transferred?
Just the primary beneficiary, Judge.
How do I know that? You got a case that tells me that?
I think that the nature of the nominee trust is that the beneficiaries direct the trustees.
Right.
Right. And if he's the primary beneficiary, he's the only one he has to consult with.
And the reason we know that is?
Because that's what the nominee trust, that's the structure of a nominee trust. The beneficiaries direct...
None of that's in the trust, okay? What you just said to me, none of that's in the trust. So it would have to be in case law that explains that if if there are contingent beneficiaries as well as if it's structured, I understand you to be saying it's structured so that the beneficiaries are Merle while he's alive and everybody else if he passes, right?
Right.
But those everybody else, they don't have to sign off on any transfers by Merle. How do I know that?
Judge, I don't have a case to cite on that. I don't.
Oh, that's problematic because that seems to me you just made that argument. This is extremely complicated to my mind. And if the judge concluded, as you say, but as she did not, that he is the only beneficiary of the trust, or the primary beneficiary of the trust, I'm wondering whether there's a trust at all. And I'll make another point. I looked today at the deed. The deed isn't signed by Merle as trustee. What do I do with that? It says Merle as trustee makes the following transfer. And then I get to the end of the deed, and before that, by the way, Merle takes a life estate, which I found kind of interesting, and then underneath that we have his name, and it doesn't say Merle as trustee, it just says Merle. What do I do with that?
I don't know if that was a scrivener's error, Judge. I'm not sure that it's significant that he signed next to the word trustee, especially where the title of the document states that he's doing it in his capacity as a trustee. So I'm not sure that that has any significance.
Well,
with respect,
so the judge says the defendant didn't prove there were other beneficiaries. The defendant says, I'm sorry, the plaintiff didn't prove there were other beneficiaries. The plaintiff says, well, it says beneficiaries. That's what the document says. And we don't have anything that indicates anybody other than Merle was involved.
we don't have
How
that
do we know
evidence.
we had a valid trust?
As I said, Judge, I think that when you set these things up, you set them in the contemplation that you may pass away. It was right after his wife had actually passed that he conveyed the properties to his son. He was, he's making his final arrangements, essentially. And so I think when you set up that trust, when he set up the trust, the judge didn't find this. It's just a possibility that he would have named contingent beneficiaries, Judge, and that way he could retain control. If it wasn't that way, if he wasn't the primary beneficiary, he couldn't have reserved a life estate. He couldn't have reserved a life estate. He wouldn't have had a life estate. He'd have no possessory interest in it.
But that's another way of saying we can't figure out what the heck happened. The judge didn't make any of those findings.
Right. I mean, in other words, you're posing a hypothetical, but which may be rational, but we should really stick to what the judge found.
I prefer that you stick to the judge's rationale, Your Honor. I think it was well-reasoned. It was very well thought through. There was no direct evidence of who the beneficiaries were of the trust. And then we get to, even if he didn't consult it, he didn't consult the beneficiaries as he was required to do so under the terms of the trust. The transferee can rely on the on the
That's an interesting
conclusive evidence
provision.
clause.
That's an interesting provision. Although it's, yeah. Do you think that, well, I know the answer to this question. I won't even bother asking. Isn't your, let's just pass over the question of whether she got that part right about that they hadn't proved the beneficial. Isn't your opponent right that the judge got the burden of proof wrong with respect to competency? Doesn't the case that they cite say exactly what your brother says?
I don't think that, you mean the burden shifting argument? So with respect to the burden shifting, I want to just bring the court's attention to a recent case which was from this court in the matter of John P. Urban, 22 P. 21. That analyzed the burden shifting, I think, in a very similar way, both to the fiduciary duty claim and to the undue influence claim. And the court in Urban case considered the burden shifting argument, and they stated that the advice of independent counsel is ineffective where the fiduciary was an intruder to the relationship between the attorneys and the testator and engaged in acts of which in effect subverted the independence of the legal representation. And there just wasn't any evidence of that. And so there wasn't any evidence of that. Of Karen Pellerin intruding into the attorney-client relationship. She wasn't the author of the deed. She didn't influence Attorney Wax in his drafting of the trust. She had, all that she did was initiate a call at her father's request. That's the only evidence that she had anything to do with it. She called Attorney Wax and said, "My dad would like to meet with you." That was the extent of her involvement, as opposed to other cases in which the intrusion into the attorney-client relationship is extensive.
Okay, but let's look at footnote 37 on page 32. The court previously discussed its finding infer that the plaintiffs did not meet their burden to prove that Merle Sr. lacked the capacity or was not competent at the time he made his transfer in November of 2006. That statement is just incorrect under the case that your brother cites, right? If there's evidence that he has Alzheimer's, it's your burden to show he was competent.
I think that that's a misreading of the burden shifting argument. I think the judge got it right. I think that you have to show some circumstances surrounding the transaction which would indicate that there was some undue influence. And they didn't even make an initial showing. All there was a diagnosis.
We're on capacity, not undue influence. So leave that one aside. It may be an issue there too, but this is on capacity. On capacity, as I read, I wish I knew the name of the case off the top of my head, but
okay.
It's a Mass Appeals Court decision, or maybe not. And it's like almost directly on point as to how the burden shifting would work in this circumstance. Once there's evidence that he has Alzheimer's, the burden is on the proponent of what he did to show that he had the capacity to do it at the time he did it. And the judge makes a statement in the footnote. So I'm asking you, what do you say to that?
I say that there was no evidence around the time that the conveyance was made that he lacked capacity, Judge. All there was a diagnosis from a year before. There was a diagnosis of Alzheimer's. That's what they're relying on for their circumstances. What you had was, the only evidence was Attorney Wax obviously thought him competent enough to have him sign a deed, right? He was there the day the transfer was made. And presumably, if he was competent, it was incompetent, Attorney Wax would have known that. He met with, according to the testimony, he met with the decedent. He met and he made the conveyance to the trust. So that's the only factual circumstances close to the transaction that indicate competency at all. And it was evidence that he was competent, not incompetent, Judge. He had a diagnosis.
But doesn't that diagnosis indicate that it's a deteriorating condition? So if that was a year ago, so doesn't that provide some evidence that that condition is likely to...
It's some evidence, Judge. It's some evidence. I would suggest that it's not very compelling if you have an attorney that drives to his house has him execute documents, he would be in the best position to know at that time, it's the time that he signed the deed that is important in terms of, capacity. It's not what a doctor diagnosed him for. And an actual incapacity wasn't found until 2008. And that's when his doctor diagnosed him or declared that he was incompetent. It didn't happen for another 2 years. So there's no evidence around the time that he made the conveyance that he lacked capacity. And so they didn't meet their initial...
I'm sorry, I don't agree with that. I read the medical records this morning. There's evidence that he lacked capacity. He couldn't remember what he was told 2 minutes before. The question is whether he lacked the capacity to do what he did. And as to that, we have statements, I believe, in 2005 and maybe early 2006 by his doctor he has the opinion that he does have the capacity. Your brother says those shouldn't have come in. Okay.
We've had a lot of questions for you, as you can tell, but I still have 2 minutes left. Is there anything else you want to bring to our attention, or?
Let me just look at my notes here, Your Honor. I think we've covered everything, Your Honor. I rest on the brief.
All right.
Thank you.
Any further questions? No. All right. Thank you both very much. Okay, that concludes our hearing today. The court will stay in recess. Thank you very much.